Para 301. Another constitution bench of this court in Nabam Rebia Supra had the occasion to discuss at length the nature of the position of the governor in the constitutional scheme, along with the source and scope of his discretionary powers. The court held that the discretionary powers of the governor could be traced back to Article 163, Clause 1, that is, he could act in exercise of his discretionary powers only where expressly provided for under the Constitution or where the interpretation of a constitutional provision could not be construed otherwise, or in cases where this court has declared the exercise of powers to be done by the governor in his discretion notwithstanding ministerial advice. Further, the court held that the finality expressed under Article 163, Clause 2 was only in respect of those situations where the exercise of discretion by the governor was permissible under the framework of Article 163, Clause 1, and any exercise of discretion beyond the jurisdiction provided by the Constitution would be subject to judicial review. The relevant observations are reproduced herein below. Quote, Para 147.1. Ellipsis of part of the para. Article 163 further warrants that the governor would exercise his functions on the aid and advice of the Council of Ministers, with the Chief Minister as the head. The above edict is not applicable in situations where the governor is expressly required to exercise his functions, quote, by or under this constitution or in his discretion, end of quote. Emphasis. The question that will need determination at our hands is whether the underlying cardinal principle with reference to the discretionary power of the governor is to be traced from Article 163, Clause 1 or from Article 163, Clause 2, ellipsis. All in all, it is apparent that the governor is not assigned any significant role in the executive functioning of the state. Para 147.2. Ellipsis. Emphasis. Insofar as the legislative process is concerned, the only function vested with the governor is expressed through Article 200, which, inter alia, provides that a bill passed by the state legislature is to be presented to the governor for his assent, and its ancillary position, namely Article 201, wherein a bill passed by the state legislature and presented to the governor may be reserved by the governor for consideration by the president. Ellipsis. All in all, it is apparent that the governor is not assigned any significant role even in the legislative functioning of the state. Para 148. The above position leaves no room for any doubt that the governor cannot be seen to have such powers and functions as would assign to him a dominating position over the state executive and the state legislature. The interpretation placed on Article 163, Clause 2 on behalf of the respondents has just that effect because of the following contentions advanced on behalf of the respondents. Firstly, whenever a question arises whether in discharging a particular function, the governor can or cannot act in his own discretion. According to the respondents, the discretion of the governor on the above question is final. Secondly, since the provision itself postulates that, quote, ellipsis, the decision of the governor in his discretion shall be final, and the validity of anything done by the governor shall not be called in question on the ground that he ought or not to have acted in his discretion, ellipsis, end of quote. According to the respondents, makes the governor's orders based on his own discretion immune from judicial review. Accepting the above position will convert the governor into an all-pervading super-constitutional authority. End of emphasis. This position is not acceptable because an examination of the executive and legislative functions of the governor from the surrounding provisions of the Constitution clearly brings out that the governor has not been assigned any significant role either in the executive or the legislative functioning of the state. The position adopted on behalf of the appellants, on the other hand, augurs well in an overall harmonious construction of the provisions of the Constitution. Even on a cursory examination of the relevant provisions of the Constitution, we are inclined to accept the contention advanced on behalf of the appellants. Para 149. In our considered view, a clear answer to the query raised above can inter alia emerge from the Constituent Assembly debates with reference to draft Article 143, which eventually came to be renumbered as Article 163 in the Constitution. It would be relevant to record that from the queries raised by H.V. Kamath, T.T. Krishnamachari, Alladi Krishnaswamy Iyer, and from the response to the same by Dr. B.R. Ambedkar, it clearly emerges that the general principle with reference to the to the scope and extent of the discretionary power of the governor is provided for through Article 163, Clause 1. It also becomes apparent from Article 163, Clause 1, which provides for the principle of ministerial responsibility. Emphasis. The crucial position that gets clarified from a perusal of the Constituent Assembly debates arises from the answer to the query whether the governor should have any discretionary power at all. The debates expound that the retention of discretionary power with the governor was not in any way contrary to the power of responsible government, nor should the same be assumed as a power akin to that vested with a governor under the Government of India Act 1935. And from that emerges the answer that the retention and vesting of discretionary powers with the governor should not be taken in the sense of being contrary to or having the effect of negating the powers of responsible government. End of emphasis. Significantly, with reference to the governor's discretionary powers, it was emphasized by Dr. B.R. Ambedkar that in Constituent Assembly Debates, Volume 8, page 501, quote, the Honorable Dr. Ambedkar. The clause is a very limited clause. It says, except insofar as he is by or under this Constitution. Therefore, Article 163 will have to be read in conjunction with such other articles which specifically reserve the power to the governor. It is not a general clause giving the governor power to disregard the advice of his ministers in any matter in which he finds he ought to disregard. End of emphasis. There, I think, lies the fallacy of the argument of my honorable friend. End of quote. In our considered view, the Constituent Assembly debates leave no room for any doubt that the framers of the Constitution desired to embody the general and basic principle describing the extent and scope of the discretionary power of the governor in Clause 1 of Article 163 and not in Clause 2 thereof as suggested by the learned counsel for the respondents. Ellipsis. Para 154. We are therefore of the considered view that insofar as the exercise of discretionary powers vested with the governor is concerned, the same is limited to situations wherein a constitutional provision expressly so provides that the governor should act in his own discretion. Additionally, a governor can exercise his functions in his own discretion in situations where an interpretation of the constitutional provision concerned could not be construed otherwise. We, therefore, hereby reject the contention advanced on behalf of the respondents that the governor has the freedom to determine when and in which situation he should take a decision in his own discretion without the aid and advice of the Chief Minister and his Council of Ministers. We accordingly also turn down the contention that whenever the governor in the discharge of his functions takes a decision in his own discretion, the same would be final and binding and beyond the purview of judicial review. We are of the view that finality expressed in Article 163, Clause 2 would only apply to functions exercised by the governor in his own discretion as are permissible within the framework of Article 163, Clause 1, and additionally in situations where the clear intent underlying a constitutional provision so requires, that is, where the exercise of such power on the aid and advice would run contrary to the constitutional scheme or would be contradictory in terms. End of emphasis. Para 155. We may therefore summarize our conclusions as under 155.1. Firstly, the measure of discretionary power of the governor is limited to the scope postulated therefore under Article 163, Clause 1. 155.2. Secondly, under Article 163, Clause 1, the discretionary power of the governor extends to situations wherein a constitutional provision expressly requires the governor to act in his own discretion. Para 155.3. Thirdly, the governor can additionally discharge functions in his own discretion where such intent emerges from a legitimate interpretation of the provision concerned and the same cannot be construed otherwise. Para 155.4. Fourthly, in situations where this court has declared that the governor should exercise the particular function at his own and without any aid or advice because of the impermissibility of the other alternative by reason of conflict of interest. Para 155.5. Fifthly, the submission advanced on behalf of the respondents that the exercise of discretion under Article 163, Clause 2 is final and beyond the scope of judicial review cannot be accepted. Firstly, because we have rejected the submission advanced by the respondents that the scope and extent of discretion vested with the governor has to be ascertained from Article 163, Clause 2 on the basis whereof the submission was canvassed. And secondly, any discretion exercised beyond the governor's jurisdictional authority would certainly be subject to judicial review. End of quote, end of emphasis. Emphasis was applied. Para 302. This court in state of Gujarat versus R.A. Mehta reported in 2013, Volume 3, SCC 1, placing reliance on the decision in BP Singhal quoted supra, observed that the expression required appearing under Article 163, Clause 1 indicated that it is only in situations where there is express stipulation or necessary implication that the governor can act in his own discretion. The term required also indicates an element of compelling necessity. The court also observed that Article 200 was one such provision where the governor is expected to act upon ministerial advice and not in his discretion. The relevant observations are reproduced herein below. Para 35. Quote. However, the power to grant pardon or to remit sentence as in Article 161, the power to make appointments, including that of the Chief Minister, as in Article 164, the Advocate General, as in Article 165, the District Judges, as in Article 233, the members of the Public Service Commission, as in Article 316, are in the category where the Governor is bound to act on the aid and advice of the Council of Ministers. Likewise, the power to prorogue either House of Legislature or to dissolve the Legislative Assembly, as in Article 174, the right to address or send messages to the houses of the legislature in Articles 175 and Article 176, the power to assent to bills or withhold such assent as in Article 200, emphasis added, the power to make recommendations for demands of grants, Article 203, Clause 3, and the duty to cause to be laid every year the annual budget, Article 202, the power to promulgate ordinances during recess of the legislature, Article 213, emphasis, also belong to this species of power, end of emphasis. Again, the obligation to make available to the Election Commission requisite staff for discharging functions conferred upon it by Article 324, Clause 1 and Article 324, Clause 6, the power to nominate a member of the Anglo-Indian community to the Assembly in certain situations in Article 333, the power to authorize the use of Hindi in proceedings in the High Court, Article 348, Clause 2, are illustrative of the functions of the governor, qua the governor. Ellipsis. Para 49. Emphasis. The exceptions carved out in the main clause of Article 163, Clause 1, permit the legislature to entrust certain functions to the governor to be performed by him, either in his discretion or in consultation with other authorities, independent of the Council of Ministers. The meaning of the words by or under is well settled. The expression by an act would mean by virtue of a provision directly enacted in the statute in question, and that which is conceivable from its express language or by necessary implication therefrom. The words under the act would in such context signify that which may not directly be found in the statute itself, but which is conferred by virtue of powers enabling such actions. Example, by way of law framed by a subordinate lawmaking authority competent to do so under the parent act. End of emphasis. Wide, Indramani Pyarelal Gupta versus W.R. Natu, AIR 1963 SC 274. Para 50. This court in Rameshwar Prasad 6 versus Union of India, quoted in 2006, Volume 2, SEC 1, held SEC page 82, para 57. Quote, para 57, the expression required found in Article 163, Clause 1 is stated to signify that the governor can exercise his discretionary powers only if there is a compelling necessity to do so. It has been reasoned that the expression by or under the Constitution means that the necessity to exercise such powers may arise from any express provision of the Constitution or by necessary implication. The Sarkaria Commission report further adds that such necessity may arise even from rules and orders made under the Constitution. End of quote, end of quote. Emphasis supplied. Section D. The decision of this court in B.K. Pavitra quoted Supra is per incuriam. Para 303. Placing reliance on the aforesaid decision in Nabam Rebia quoted Supra, this court in B.K. Pavitra quoted Supra, while dealing with the reservation of bills for the consideration of the President under Article 200, observed thus, quote, Para 66. Where a bill is not a money bill, the governor may return the bill for reconsideration, upon which the House or Houses, as the case may be, will reconsider the desirability of introducing the amendments which the governor has recommended. If the bill is passed again by the House or Houses, as the case may be, the governor cannot thereafter withhold assent. The second proviso to Article 200 stipulates that the governor must not assent to a bill but necessarily reserve it for the consideration of the President if the bill, upon being enacted, would derogate from the powers of the High Court in a manner that endangers its position under the Constitution. Emphasis. Save and except for bills falling within the description contained in the second proviso, where the governor must reserve the bill for consideration of the president, a discretion is conferred upon the governor to follow one of the courses of action enunciated in the substantive part of Article 200. Aside from bills which are covered by the second proviso, where the governor is obliged to reserve the bill for the consideration of the president, the substantive part of Article 200 does not indicate specifically the circumstances in which the governor may reserve a bill for the consideration of the president. The Constitution has entrusted this discretion to the governor. End of emphasis. The nature and scope of the discretionary power of the governor to act independent of or contrary to aid and advice of Council of Ministers under Article 163 was discussed in Nabam Rebia and Bamang Felix versus Arunachal Pradesh Legislative Assembly 2016. Volume 8, SCC 1, J.S. Kehar, Justice, as the learned Chief Justice then was, held thus. SCC, page 159, para 154. Quote, para 154. Emphasis. We are, therefore, of the considered view that insofar as the exercise of discretionary powers vested with the governor is concerned, the same is limited to situations wherein a constitutional provision expressly so provides that the governor should act in his own discretion. Additionally, a governor can exercise his functions in his own discretion in situations where an interpretation of the constitutional provision concerned could not be construed otherwise. End of emphasis, end of quote. Deepak Mishra, Justice, as the learned judge then was, observed thus. SCC, page 244, para 375. Quote, para 375, ellipsis of part of the para. Emphasis. The governor is expected to function in accordance with the provisions of the Constitution and the history behind the enactment of its provisions, the law and the rules regulating his functions. End of quote. It is easy to forget that the governor is a constitutional or formal head. Nevertheless, like everybody else, he has to play the game in accordance with the rules of the game, whether it is in relation to the executive, aid and advice of the Council of Ministers or the legislature, rules of procedure and conduct of business of the Arunachal Pradesh Legislative Assembly. This is not to say that the governor has no powers. He does, but these two are delineated by the Constitution, either specifically or by necessary implication. End of quote. Para 67, emphasis. The framers carefully eschewed defining the circumstances in which the governor may reserve a bill for the consideration of the president. By its very nature, the conferment of the power cannot be confined to specific categories. Exigencies may arise in the working of the Constitution which justify a recourse to the power of reserving a bill for the consideration of the President. They cannot be foreseen with the vision of a soothsayer. The power having been conferred upon a constitutional functionary, it is conditioned by the expectation that it would be exercised upon careful reflection and for resolving legitimate concerns in regard to the validity of the legislation. The entrustment of a constitutional discretion to the governor is premised on the trust that the exercise of authority would be governed by constitutional statesmanship. In a federal structure, the conferment of this constitutional discretion is not intended to thwart democratic federalism. The state legislatures represent the popular will of those who elect their representatives. They are the collective embodiments of that will. The act of reserving a bill for the assent of the president must be undertaken upon careful reflection, upon a doubt being entertained by the governor about the constitutional legitimacy of the will which has been passed. End of emphasis. Ellipsis. Para 71. These decisions are specifically in the context of Article 254. Article 254 Clause 1 postulates inter alia that in a matter which is governed by the concurrent list, a law which has been enacted by the legislature of a state shall be void to the extent of its repugnancy with a law enacted by Parliament. Clause 2 of Article 254 obviates that consequence where the law has been reserved for the consideration of the President and has received assent. Emphasis. Article 254 Clause 1 is made subject to Clause 2, thereby emphasizing that the assent of the President will cure a repugnancy of the state law with a law enacted by Parliament in a matter falling in the concurrent list. It is in this context that the decisions of this court hold that the assent of the President should be sought in relation to a repugnancy with a specific provision contained in a parliamentary legislation so as to enable due consideration by the President of the ground on which assent has been sought. Article 200 contains the source of the constitutional power which is conferred upon the governor to reserve a bill for the consideration of the President. Article 254, Clause 2 is an illustration of the constitutional authority of the governor to reserve a law enacted by the state legislature for consideration of the President in a specified situation where it is repugnant to an existing law or to a parliamentary legislation on a matter falling in the concurrent list. The eventuality which is specified in Article 254, Clause 2, does not exhaust the ambit of the power entrusted to the Governor under Article 200 to reserve a bill for the consideration of the President. Apart from a repugnancy in matters falling in the concurrent list between state and parliamentary legislation, a Governor may have sound constitutional reasons to reserve a bill for the consideration of the President. Article 200, in its second proviso, mandates that a bill which derogates from the power of the High Court must be reserved for the consideration of the President. Apart from bills which fall within the description set out in the second proviso, the Governor may legitimately refer a bill for consideration of the President upon entertaining a legitimate doubt about the validity of the law. By its very nature, it would not be possible for this court to reflect upon the situations in which the power under Article 200 can be exercised. End of emphasis. This was noticed in the judgment of this court in Hext Pharmaceuticals Limited versus State of Bihar, 1983, Volume 4, SCC 45, 1983, SCC Tax 248. Excluding it from judicial scrutiny, the court held in SCC pages 100 to 101, para 86, quote, para 86, ellipsis, emphasis, there may also be a bill passed by the state legislature where there may be a genuine doubt about the applicability of any of the provisions of the Constitution which require the assent of the President to be given to it in order that it may be effective as an act. In such a case, it is for the governor to exercise his discretion and to decide whether he should assent to the bill or should reserve it for consideration of the President to avoid any future complication. End of emphasis. Even if it ultimately turns out that there was no necessity for the governor to have reserved a bill for the consideration of the President, still he having done so and obtained the assent of the President, the act so passed cannot be held to be unconstitutional on the ground of want of proper assent. This aspect of the matter, as the law now stands, is not open to scrutiny by the courts. In the instant case, the finance bill, which ultimately became the act in question, was a consolidating act relating to different subjects, and perhaps the governor felt that it was necessary to reserve it for the assent of the president. We have no hesitation in holding that the assent of the president is not justiciable, and we cannot spell out any infirmity arising out of his decision to give such assent. End of quote, emphasis supplied. Para 304. This court in B.K. Pavitra quoted Supra took the view that the constitution has entrusted the governor with the discretion of reserving a bill presented to him for assent for the consideration of the president. It also held that the exercise of the power of reservation of bills for the consideration of the president could be done by the governor contrary to the aid and advice tendered by the council of ministers. The court observed that such an important responsibility having been conferred upon a constitutional functionary, its discharge was expected to be undertaken upon careful reflection and with statesmanship, and in a manner that does not thwart democratic federalism. On the nature of bills which may be reserved for the consideration of the president, the court held that it was impossible to lay down with certainty all the situations wherein such a reference may be warranted. Para 305. We find ourselves in disagreement with the view taken in B.K. Pavitra, quoted Supra, that the Constitution confers a discretion upon the governor insofar as the reservation of bills for the consideration of the president is concerned. We say so because the removal of the expression in his discretion from Section 75 of the Government of India Act 1935, when it was being adapted as Article 200 of the Constitution, clearly indicates that any discretion which was available to the governor under the Government of India Act 1935 in respect of reservation of bills became unavailable with the commencement of the Constitution. The views expressed by the members of the Constituent Assembly, which are recorded in the debates that took place on Article 175 of the draft Constitution, also indicate the same. We are also of the view that the same is also in alignment with the fundamental tenets of responsible government in a parliamentary democracy. The only exception to the general principle of the governor adhering to the aid and advice tendered by the Council of Ministers can be traced to Article 163, Clause 1, and the second proviso to Article 200. Para 306. Pertinently, the court in B.K. Pavitra, quoted Supra, failed to take into consideration the larger bench decisions in Samsher Singh, quoted Supra, and MP Special Police, quoted Supra. As we have discussed above, paragraphs 54 to 56 of the decision in Samsher Singh, quoted Supra, make it clear beyond any doubt that there is no express requirement under the Constitution for the exercise of discretion by the governor in discharge of his functions under Article 200, except to the limited extent of the second proviso, where the expression in his opinion is employed for the governor. This is also apparent from the conscious decision of the Constituent Assembly in removing the expression in his discretion while enacting Article 200. Thus, the only express stipulation where the governor may exercise discretion for reservation of bills is in the second proviso to Article 200. Even when looked at from the perspective of necessary implication, the discretion of the governor in reserving the bills for the consideration of the president can be said to be present only in those cases where the Constitution has envisaged a mandatory approval of the government before the law can become enforceable in the state. The Sarkaria Commission mentioned three categories where reservation of a bill for the consideration of the president is envisaged. A. First, where the bill pertains to the second provision, sorry, to the second proviso of Article 200, Article 288, Clause 2, or Article 360, Clause 4, Subclause A, Subclause 2 of the Constitution. Reservation for the President is a mandatory condition as the bill will not become effective without his assent. Item B. Secondly, where the bill pertains to Articles 31A, Clause 1 or 31C, presidential assent is compulsory for securing immunity from the operation of Articles 14 and 19. Similarly, where the law is repugnant to a union legislation on a concurrent list subject matter, presidential assent is required to make the law effective in the state. Further, laws made under Article 304, Clause B would not be enforceable if they were introduced without the previous sanction of the president and having been introduced and passed by the state legislature have not received the assent of the President. This position can be derived from a reading of Article 255. Item C. Thirdly, there may be laws falling outside the aforesaid categories which may be reserved by the Governor by the President. However, the scope of discretion in such category of laws would be extremely limited and only when an exceptional situation of the nature described by this court in MP Special Police quoted Sutra and in Nabam Rebia quoted Sutra as explained by us in paragraph 300 of this judgment arises that there would be scope for the Governor to reserve the bill for the consideration of the President. Para 307. While considering the role of the Governor in the context of Article 200, we must keep in mind that such a role has been envisaged not to supplant the opinion of the Council of Ministers but to infuse it with his wisdom. The role of a friend, philosopher, and a guide which a governor is to play under the Constitution is played by him at various stages of administrative and legislative functioning of the state. Article 167 makes it mandatory for the Chief Minister to share with the Governor inter alia the proposals of legislations that the Governor wishes to introduce in the state legislature. This means that the Governor is made well aware of any legislation that the state government is planning to enact much before it is introduced in the state legislature and sent to him for assent. Thus, the advisory role of the governor is best played by engaging with the Council of Ministers even before the legislation is introduced in the state legislature. He is well within his rights, and in fact, it is his bounden duty to put to use his experience and wisdom by making constructive suggestions to the cabinet regarding the legislative proposals. The Council of Ministers would also do good to take into consideration the advice of the governor and deliberate upon it so that the legislation and ultimately public interest is benefited. Para 308. However, once the bill is passed by the state legislature and presented to the governor for assent, he must act on the aid and advice of the Council of Ministers as a general rule and only in exceptional situations which have been illustrated in paragraph 300 of this judgment should he reserve it for the consideration of the President. A look at Rule 48 of the Tamil Nadu Government Business Rules 1978 makes it clear that once a draft bill is approved by the minister in charge, a copy of it is supplied to the governor. Rule 48 reads thus. Quote, Rule 48, Section 1. If the tentative draft bill is approved by the minister in charge, it shall be circulated to the other ministers and a copy supplied to the governor, and unless the chief minister directs otherwise, the tentative draft bill shall be brought before a meeting of the council. Proposals for any substantial or important amendments in the draft bill after its approval shall also be dealt with similarly. End of quote. Para 309. After circulation of the bill to the governor, any suggestions made by the governor may be looked into and incorporated. Thereafter, a final copy of the bill as approved by the law department is also circulated to the governor. Rule 51, Clause B, which provides for it, reads thus. Quote, Subrule B. The originating department shall also prepare a notice of motion to introduce a bill and shall, after obtaining the signature of the minister in charge, forward the notice to the secretary to the chamber of the legislature to which it is proposed to introduce the bill. The department will be in charge of the bill in all its subsequent stages. The originating department shall, while giving notice of motion to the assembly or council department, submit a copy of the bill as finalized by the law department to the governor. Para 310. As our discussion on the Constituent Assembly debates also reveals, the option of withholding assent was believed by the framers would be invoked in very rare circumstances where the Council of Ministers discover some error in the legislation or desire to incorporate certain changes to it so as to meet with the popular opinion outside the House. The framers did not expect that the governor would, as a matter of routine, declare the withholding of assent to bills casually. The deletion of the expression in his discretion from the first proviso is also an unmistakable indication of the intent of the framers investing no discretion in the governor as regards the withholding of assent and returning of the bill along with suggestions for the introduction of amendments. Para 311. B.K. Pavitra quoted Supra made a reference to paragraph 375 of the decision in Nabam Rebia quoted Supra to support the idea that the governor is entrusted with discretion in the exercise of his powers under Article 200. However, it is pertinent to note that in the said paragraph, the court observed that, quote, the governor is expected to function in accordance with the provisions of the Constitution and the history behind the enactment of its provisions. End of quote. The history behind the enactment of Article 200 is loud and clear and speaks for itself as regards the intention of the framers of the Constitution, as we have discussed in detail. Para 312. What also needs to be remembered is that whenever a provision of the Constitution prescribes for the assent of the President for the purpose of enforceability or securing immunity, any state government would, in all likelihood, advise the governor to reserve the bill for the consideration of the President. Even the Tamil Nadu Government Business Rules 1978 prescribe the procedure for pre-consultation with the central government whenever a subject matter falling in the concurrent list or certain other constitutional provision is being legislated upon. As we have also discussed, the position settled by Kesar A. Hind, quoted Supra, is that the reference to the president needs to be detailed and specific so as to enable him to undertake an effective consideration of the reserved bill. In the practical working of a cabinet form of government, it is the Council of Ministers who would be best equipped to make such detailed references to the President, and the Governor would act as the bridge connecting the two. It is only in rare cases where, in spite of the evident requirement for the President's assent in order to make the bill effective as an act, as observed in paragraph 86 of Hext quoted Supra, the Council of Ministers has failed to advise the governor to reserve the bill for the president should the governor decide to reserve the bill on his own motion. Para 313. A reference must also be made at this point to the observation made by this court in Valluri Basavaya Chowdhury quoted Supra, wherein it was observed thus. Quote, Para 19. The governor is, however, made a component of the legislature of a state under Article 168 because every bill passed by the state legislature has to be reserved for the assent under Article 200. Under that article, the governor can adopt one of the three courses, namely, number one, he may give his assent to it, in which case the bill becomes a law, or number two, he may accept in the case of a money bill without his assent therefrom, in which case the bill falls through unless the procedure indicated in the first proviso is followed, that is, return the bill to the assembly for reconsideration with a message. Or number three, he may, subject to ministerial advice, reserve the bill for the consideration of the president, in which case the president will adopt the procedure laid down in Article 201. The first proviso to Article 200 deals with a situation where the governor is bound to give his assent when the bill is reconsidered and passed by the assembly. End of emphasis. The second proviso to that article makes the reservation for consideration of the president obligatory, where the bill would, if it becomes law, derogate from the powers of the High Court. Thus, it is clear that a bill passed by a state assembly may become law if the governor gives his assent to it, or if, having been reserved by the governor for the consideration of the president, it is assented to by the president. The governor is therefore one of the three components of a state legislature. The only other legislative function of the governor is that of promulgating ordinances under Article 213, Clause 1, when both the houses of the state legislature or the legislative assembly, where the legislature is unicameral, are not in session. The ordinance making power of the governor is similar to that of the president, and it is coextensive with the legislative powers of the state legislature. End of quote. Emphasis supplied. Para 314. As discussed earlier, D.D. Basu has also taken a similar view in his commentary on the Constitution of India. The position prevailing in a number of international jurisdictions, as discussed in the preceding parts of this judgment, also lends credence to this view. Para 315. The deletion of the expression in his discretion, both from the substantive part of Article 200 as well as from the first proviso to it, signifies that the intention of the framers of the Constitution was to ensure that the ordinary exercise of governor's function under Article 200 was to be in accordance with the aid and advice tendered to him by the Council of Ministers. The view expressed by Sri Brajeshwar Prasad that the governor should be confirmed sorry, should be conferred with some veto to negate an unsound legislation was expressly rejected by the Constituent Assembly. Further, it was explained by Mr. T. T. Krishnamachari that the first proviso was in the form of a saving clause where the Council of Ministers could ask the governor to hold up a bill in which certain errors were discovered subsequent to its passage in the House or Houses, or to suitably respond to the popular sentiment expressed after such a passage. Pertinently, during the course of the debates, it was observed by Dr. Ambedkar that in a responsible form of government, there can be no room for the governor to act in his discretion. Para 316. The deletion of the words in his discretion from Section 75 of the Government of India Act 1935 before adapting it as Article 200 of the Constitution must be understood in the right context. The Government of India Act 1919 introduced an element of provincial autonomy in the administration of the country. However, the governor remained at the center of administration, having reserve as well as emergency powers. With the advent of the Government of India Act 1935, the diarchy at the provincial level was abolished, but the governor, as the agent of the British Crown, continued to have the discretion to veto any legislation passed by the provincial legislature. The governor could also, in his discretion, reserve any bill for the consideration of the Governor General. This power of the governor was to be essentially exercised in accordance with the directions of the Governor General. However, with the dawn of independence and the framing of the Constitution, the model of governance which was adopted allowed the states to be supreme in their respective fields, with certain powers having been reserved for the Union to ensure the integrity of the nation and uniformity of policy in certain key areas. The governor was no more required to have an all pervasive control over the state, and their responsibility towards the union was to the extent of ensuring that the administration in the state was being done in conformity with the principles enshrined in the constitution. It is in this context that the power of the governor to submit a report to the president under Article 356 and also the power under Article 200 to reserve a bill for the consideration of the president is to be understood. Para 317. The governor under the constitutional scheme is no longer envisaged as the governor under the Government of India Act 1935, having the ultimate power to veto any legislation and subvert the collective will of the people being expressed through the legislature. If the power to withhold assent to bills or to reserve them for the consideration of the president is construed as falling within the exclusive discretionary domain of the governor, who would be free to decide a course of action notwithstanding the aid and advice of the Council of Ministers, it would have the potential of turning him into a super constitutional figure, having the power to bring to a complete halt the operation of the legislative machinery in the state. The governor cannot be vested with such a power, the exercise of which would enable him to collude with the Union Cabinet and ensure the death of any and all legislation initiated by the state merely by reserving it for the consideration of the President, who under Article 201 is not bound to give assent to any legislation reserved for his consideration. Para 318. Thus, we are of the view that the governor does not possess any discretion in the exercise of his functions under Article 200 and has to mandatorily abide by the advice tendered to him by the Council of Ministers. The only exceptions to this general rule are as follows. Item A. Where the bill is of a description as provided under the second proviso to Article 200. Item B. Where the bill is of a nature covered by Articles 31A, 31C, 254, Clause 2, 288, Clause 2, 360, Clause 4, Subclause A, Subclause 2, etc., wherein assent of the President is a condition precedent before the bill can take effect as law or is necessary for the purpose of securing immunity against the operation of some constitutional provision. Item C. Where the bill is of a nature that, if allowed to take effect, then it would undermine the Constitution by placing the fundamental principles of a representative democracy in peril as described in MP Special Police quoted supra. Para 319. Exception A, as mentioned above, is one which is expressly provided by the Constitution to fall within the ambit of discretionary powers of the governor. Exception D Exception B flows from a reading of those provisions which require the mandatory assent of the President to a bill passed by the state legislature and thus are to be construed in light of the observations made in Nabam Rebia quoted supra as instances, quote, where such intent emerges from a legitimate interpretation of the provision concerned and the same cannot be construed otherwise, end of quote. Exception C has to be construed and understood in the context of the observations made by this court in MP Special Police quoted supra as covering such quote situations where by reason of peril to democracy or democratic principles an action may be compelled which from its nature is not amenable to ministerial advice, end of quote. Section 5. Whether the exercise of discretion by the governor in discharge of his functions under Article 200 of the Constitution could be said to be subject to judicial review. If yes, what are the parameters for such judicial review? Quote, be your ever so high, the law is above you. End of quote. Actually, I think it is be you ever so high, the law is above you by Thomas Fuller. Para 320. We have extensively discussed in the preceding section that the governor under the scheme of Article 200 would, as a general rule, be expected to act on the aid and advice of the Council of Ministers as provided for under Article 163, Clause 1. The deletion of the expression in his discretion by the framers of the Constitution during the course of adapting Section 75 of the Government of India Act 1935 into Article 200 is a clear indication of their intent to make the ordinary exercise of powers of the governor under Article 200 subject to the aid and advice of the Council of Ministers. However, the aforesaid ordinary exercise of power by the governor is subject to certain exceptions where the governor may act in his own discretion contrary to the advice of the Council of Ministers. There are two broad circumstances under which it would be permissible for the governor to act in his own discretion under Article 200. Item A. Where the governor is by or under the Constitution required to act in his discretion. The only situation in which such exercise of discretion has been explicitly laid down in the Constitution is the second proviso to Article 3 that is, where in the opinion of the governor the bill, if assented to, would so derogate from the powers of the High Court as to endanger the position which the High Court is designed to fill by the Constitution. Item B. Where the governor is by necessary implication required to act in his own discretion. This would include Item 1. Where a bill attracts such a provision of the Constitution which requires the mandatory assent of the President for securing immunity or making the law enforceable. Exercise of discretion is permissible in these cases. For instance, Articles 31A, 31C, 254 Clause 2, 288 Clause 2, 360 Clause 4, subclass A, subclass 2, etc. Item 2. Situations where the exceptional conditions as described in MP Special Police quoted supra and Nabam Rebia quoted supra are applicable. That is, the State Council of Ministers has disabled or disentitled itself possibility of complete breakdown of the rule of law or by reason of peril to democracy or democratic principles respectively, as a consequence of which an action may be compelled which by its nature is not amenable to ministerial advice. Para 321. The question which naturally follows is whether the exercise of discretion by the governor in the exceptional situations as discussed aforesaid would be amenable to judicial review. The importance of this question lies in the high constitutional importance of the role which the governor plays under Article 200. The governor, by choosing to act in his discretion under Article 200, has the power to thwart the entire legislative machinery of the state by reserving a bill for the consideration of the President. He also has the power to significantly delay the grant of assent to a bill by withholding assent and returning the same to the state legislature under the first proviso to Article 200 of the Constitution. Para 322. It was contended by the petitioner that no exercise of power under the Constitution could be said to be beyond the scope of judicial review, as every authority, howsoever high, is expected to perform its functions within the constitutional framework. It was submitted that if the exercise of powers by the governor under Article 200 is held to be outside the scope of judicial review, then that would render him to be a super constitutional figure in the state who would be able to override the legislature and the government elected by the people at his whims and fancies and without any checks and balance. Para 323. Refuting the contention of the petitioner, the Attorney General for India placed reliance on the decisions of this court in Hext quoted Supra, Kaisar-e-Hind quoted Supra, and B.K. Pavitra quoted Supra to argue that the grant of assent under Articles 200 and 201 respectively has been previously held to be non-justiciable by this court. Para 324. Essentially, the questions that fall for our consideration are as follows. Item 1. First, whether the discharge of functions by the governor under Article 200 of the Constitution in his discretion could be said to be immune from judicial review. Item 2. Secondly, whether the withholding of assent by the President under Article 200 of the Constitution could also be said to be beyond the scope of judicial scrutiny. Item 3. Thirdly, if the aforesaid discharge of functions is subject to judicial review, whether such discharge of functions could be said to be non-justiciable in light of the decisions of this court in Hext, quoted Supra, Kesari Hind, quoted Supra, and B.K. Pavitra, quoted Supra. Para 325. Samsher Singh, quoted Supra, in paragraph 54 observed that, quote, the discretion conferred upon the governor means that as the constitutional or formal head of the state, the power is vested in him. End of quote. We have also discussed in detail in the preceding sections that the source of all discretion for the governor is to be found within Article 163, Clause 1 of the Constitution alone. Thus, what falls for us to decide is whether the exercise of this constitutional power by the governor could be said to be amenable to judicial review, where such exercise is assailed on the ground that it transgresses the boundaries set by the Constitution. This court has had the occasion of discussing the concept of judicial review in a catena of cases. We are of the view that for a better exposition and enlightenment on this issue, it would be prudent and beneficial to make a reference to all these decisions. Para 326. In Maruram quoted Supra, this court, speaking eruditely through the inimitable Krishna Iyer J., observed that all public power, including constitutional powers of pardon, commutation, and release under Articles 72 and 161 of the Constitution respectively, cannot run riot or be exercisable irrationally or arbitrarily. Any action under these provisions must be informed by the finer canons of constitutionalism. In his words, quote, the rule of law under our constitutional order transforms all public power into responsible, responsive, regulated exercise informed by high purposes and geared to people's welfare. End of quote. It held that all the powers entrusted by the Constitution must, in its exercise, eschew any form of arbitrariness and stem from an intelligible and well-reasoned criterion that is predicated on an earnest purpose. It further categorically held that, quote, while constitutional power is beyond challenge, its actual exercise may still be vulnerable, end of quote, to judicial review. In the last, Krishna Iyer Justice further cautioned that such power ought not to be vulgarized or abused by personal vanity and the notions of those exercising such powers. The relevant observations read as under. Quote, Para 62. An issue of deeper import demands our consideration at this stage of the discussion. Wide as the power of pardon, commutation, and release, as in Article 72 and 161 is, it cannot run riot. Emphasis, for no legal power can run unruly like John Gilpin on the horse, but must keep sensibly to a steady course. Here we come upon the second constitutional fundamental, which underlines the submissions of the Council. It is that all public power, including constitutional power, shall never be exercisable arbitrarily or mollified, and ordinarily guidelines for fair and equal execution are guarantors of the valid play of power. We proceed on the basis that these axioms are valid in our constitutional order. Para 63. The jurisprudence of constitutionally canalized power, as spelled out in the second proposition, also did not meet with serious resistance from the learned Solicitor General, and if we may say so rightly. Emphasis. Article 14 is an expression of the egalitarian spirit of the Constitution and is a clear pointer that arbitrariness is anathema under our system. It necessarily follows that the power to pardon, grant remission, and commutation, being of the greatest moment for the liberty of the citizen, cannot be a law unto itself but must be informed by the finer canons of constitutionalism. Ellipsis. It is the pride of our constitutional order that all power, whatever its source, must in its exercise anathematize arbitrariness and obey standards and guidelines intelligible and intelligent and integrated with the manifest purpose of the power. End of emphasis. From this angle, even the power to pardon, commute, or remit is subject to the wholesome creed that guidelines should govern the exercise even of presidential power. Ellipsis. Para 65. Pardon, using this expression in the amplest connotation, ordains fair exercise as we have indicated above. Emphasis. Political vendetta or party favoritism cannot but be interlopers in this area. The order, which is the product of extraneous or malified factors, will vitiate the exercise. While constitutional power is beyond challenge, its actual exercise may still be vulnerable. Likewise, capricious criteria will void the exercise. For example, end of emphasis. For example, if the chief minister of a state releases everyone in the presence in his state on his birthday or because his son has been born to him, it will be an outrage on the constitution to let such madness survive. End of emphasis. Ellipsis. Push this logic a little further and the absurdity will be obvious. Emphasis. No constitutional power can be vulgarized by personal vanity of men in authority. Likewise, if an opposition leader is sentenced, but the circumstances cry for remission, such as that he is suffering from cancer, or that his wife is terminally ill, or that he has completely reformed himself, the power of remission under Article 72 or 161 may ordinarily be exercised and a refusal may be wrong-headed. End of emphasis. If, on the other hand, a brutal murderer, bloodthirsty in his massacre, has been sentenced by a court with strong observations about his bestiality, it may be arrogant and irrelevant abuse of power to remit his entire life sentence the very next day after the conviction merely because he has joined the party in power or is a close relation of a political high-up. Ellipsis, end of quote, emphasis supplied. Para 327. This court, speaking through 9 judges in Indra Sane versus Union of India, reported in 1992, Supplementary 3, SCC 217, held that the yardstick of subjecting an act or a decision to judicial review is not whether it is a legislative act or an executive decision on a policy matter, but whether it violates any constitutional guarantee or the rights under Part 3 of the Constitution. The court further held that the doctrine of political ticket does not apply in the Indian constitutional framework. It is not that the courts avoid entering into a political question because of the doctrine of separation of power, but because of desirability of avoiding entering into a political question. The relevant observations are reproduced herein below. Quote, para 557, part of the para ellipsed. The political questions doctrine, however, does not mean that anything that is tinged with politics or even that any matter that might properly fall within the domain of the President or the Congress shall not be reviewable, for that would end the whole constitutional function of the court. End of quote. As quoted in Samuel Krislov, The Supreme Court in the Political Process, page 96. Under our Constitution, emphasis. Under our Constitution, the yardstick is not if it is a legislative act or an executive decision on a policy matter, but whether it violates any constitutional guarantee or has potential of constitutional repercussions as enforcement of an assured right under Chapter 3 of the Constitution by approaching courts is itself a fundamental right. The constitutional fiction of political question, therefore, should not be permitted to stand in way of the court to deny the nation the guidance on basic democratic principles. Quote from C. Herman Pritchett, The American Constitution, page 154, quoted in the Judicial Review of Legislative Acts by Dr. Chakradhar Jha, page 355. Avoidance of entering into a political question may be desirable and may not be resorted to, quote, not because of doctrine of separation of power or lack of rules, but because of expediency, end of quote. The quote is from Charles Gordon Post, pages 129 to 130, the Supreme Court questions quoted in the Judicial Review of Legislative Acts by Dr. Chakradhar Jha, page 351. In larger interest for public good, but legislatures to have, quote, their authority measured by the Constitution, end of quote. Therefore, absence of norms to examine political question has rarely any place in the Indian constitutional jurisprudence. Ellipsis, end of quote. Emphasis supplied. Para 328. Further, this court in B.P. Singhal quoted Supra upon examining a catena of decisions on the scope and evolution of the power of judicial review of the courts observed that although under the English law, the prerogative powers of the monarch such as the power to make treaties, grant mercy or to dissolve the parliament etc. are traditionally not subject to judicial review due to the very nature of such powers falling outside the expertise and competence of the courts, yet such preclusion of the power of judicial review is by no means a blanket rule. It observed that even prerogative powers, insofar as the questions of legality, rationality, or procedural propriety are concerned, would always be amenable to judicial review because the safeguarding of such considerations in the exercise of any prerogative powers is the domain, responsibility, and duty of the courts as the sentinel on the qui vive. Placing reliance on the decision of this court in State of Rajasthan versus Union of India, reported in 1977, Volume 3, SCC 592, it held that the courts, as the protector and ultimate interpreter of the Constitution, not only have the power but an obligation to determine the power conferred on each branch of the government, the extent and limits of such powers, and whether the exercise of such power exceeds those limits or not, irrespective of whether such powers are the exclusive prerogative of any one branch of the government or such questions are inherently political in complexion. The relevant observations read as under. Quote, Para 72. The traditional English view was that prerogative powers of the Crown conferred unfettered discretion which could not be questioned in courts. Lord Ruskell attempted to enumerate such prerogative powers in Council of Civil Services Union versus Minister for Civil Service, 1985 AC 374, 1984 3 WLR 1174, 1984 3 All ER 935 HL AC P 413. Quote, ellipsis. Prerogative powers such as those relating to the making of treaties, defense of the realm, the prerogative of mercy, the grant of honors, the dissolution of parliament, and the appointment of ministers, as well as others, are not, I think, susceptible to judicial review because their nature and subject matter is not to be amenable to the judicial process. The courts are not the place wherein to determine whether a treaty should be concluded or the armed forces disposed in a particular manner or parliament dissolved on one date rather than another. End of quote. However, the contemporary English view is that in principle even such political questions and exercise of prerogative power will be subject to judicial review on principles of legality, rationality or procedural impropriety. See decision of House of Lords in R. Bancolt versus Secretary of State for Foreign and Commonwealth Affairs, number 2, 2009, 1 AC 453 HL. In fact, D. Smith's Judicial Review, 6th edition, 2007, page 15, states, quote, judicial review has developed to the point where it is possible to say that no power, whether statutory or under the prerogative, is any longer inherently unreviewable. Courts are charged with the responsibility of adjudicating upon the manner of the exercise of public power, its scope and its substance. As we shall see, even when discretionary powers are engaged, they are not immune from judicial review. End of quote. Para 73, in State of Rajasthan versus Union of India, 1977, Volume 3, SCC 592, this court, Bhagwati Justice as he then was, held in SCC pages 660 to 62, Para 49, Para 149, quote, Para 149, ellipsis of part of the para, but merely because a question has a political complexion, that by itself is no ground why the court should shrink from performing its duty under the Constitution if it raises an issue of constitutional determination. Ellipsis. The court cannot fold its hands in despair and declare judicial hands off so long as a question arises whether an authority under the Constitution has acted within the limits of its power or exceeded it. It can certainly be decided by the court. Indeed, it would be its constitutional obligation to do so. Ellipsis. This court is the ultimate interpreter of the Constitution, and to this court is assigned the delicate task of determining what is the power conferred on each branch of the government, whether it is limited, and if so, what are the limits, and whether any action of that branch transgresses such limits. It is for this court to uphold the constitutional values and to enforce the constitutional limitations. That is the essence of the rule of law. Ellipsis. Where there is manifestly unauthorized exercise of power under the Constitution, it is the duty of the court to intervene. Let it not be forgotten that to this court, as much as to other branches of government, it is committed the conservation and furtherance of democratic values. The court's task is to identify those values in the constitutional plan and to work them into life in the cases that reach the court. Ellipsis. The court cannot and should not shirk its responsibility. Ellipsis. End of quote. In the said decision, Chandrachud Justice, as he then was, observed thus: SCC page 645, para 132, quote, para 132, ellipsis of part of the para. They may not choose to disclose them, but if they do, as they have done now, they cannot prevent a judicial scrutiny, thereof for the limited purpose of seeing whether the reasons bear any rational nexus with the action proposed. I am inclined to the opinion that the government cannot claim the credit at the people's bar for fairness in disclosing the reasons for the proposed action, and at the same time deny to this court the limited power of finding whether the reasons bear the necessary nexus or are wholly extraneous to the proposed action. The argument that if the minister need not give reasons, what does it matter if he gives bad ones, overlooks that bad reasons can destroy a possible nexus and may vitiate the order on the ground of mala-fides. End of quote. Para 329. Further, B.P. Singhal, quoted supra, categorically held that, unlike England, all powers that have been conferred upon the President and the Governor by the Constitution are not a matter of prerogative but a constitutional responsibility, and its exercise a matter of performance of an official duty of the highest sanctity, and thus unquestionably admissible to judicial review. It observed that the sufficiency of the attending facts and circumstances necessitating the exercise of such powers is to be decided by the President or the Governor. However, the question of whether such exercise is predicated upon all relevant cogent materials and falls within the limitations of the constitutional scheme and is not a result of an arbitrary or mollified exercise would be subject to the judicial review of the courts. Placing reliance on Maruram, quoted supra, it held that the exercise of such powers by the President only carries with it a notional presumption of a careful and proper exercise based on objective considerations, but by no stretch of imagination can it be construed to confer an immunity from judicial review. It further explained, in the context of Article 72 of the Constitution, the standard of judicial review that the courts are expected to apply when scrutinizing the exercise of such power by the President. It held that where reasons have been given for the exercise of such power, there the courts may interfere only if the reasons are based on irrelevant or extraneous considerations. However, where no reasons have been given, there the courts may interfere only if the exercise is vitiated by a flawed understanding of the ambit of such power, by misjudgment, or is otherwise arbitrary, discriminatory, or mollified. The relevant observations read as under. Para 76. This court has examined in several cases The scope of judicial review with reference to another prerogative power, power of the president, governor to grant pardon, etc., and to suspend, remit, or commute sentences. The view of this court is that the power to pardon is a part of the constitutional scheme and not an act of grace as in England. It is a constitutional responsibility to be exercised in accordance with the discretion contemplated by the context. It is not a matter of privilege but a matter of performance of official duty. Emphasis. All public power, including constitutional power, shall never be exercisable arbitrarily or mollified. While the president or the governor may be the sole judge of the sufficiency of facts and the propriety of granting pardons and reprieves, the power being an enumerated power in the Constitution, its limitations must be found in the Constitution itself. The courts exercise a limited power of judicial review to ensure that the president considers all relevant materials before coming to his decision. As the exercise of such power is of the widest amplitude, whenever such power is exercised, it is presumed that the president acted properly and carefully after an objective consideration of all aspects of the power. Where reasons are given, the court may interfere if the reasons are found to be irrelevant. However, when the reasons are not given, the court may interfere only where the exercise of power is vitiated by self denial on wrong appreciation of the full amplitude of the power under Article 72 or where the decision is arbitrary, discriminatory, or mollified. End of emphasis. Wide Maru Ram versus Union of India, quoted in 1981, Volume 1, SCC 107, 1981, SCC Criminal 112, Kehar Singh versus Union of India, quoted in 1989, Volume 1, SCC 204, 1989, SCC Criminal 86, etc. End of quote. Emphasis supplied. 330. In Kesham Supra, this court had held that a speaker acting under the 10th schedule of the Constitution would be duty bound to decide the disqualification petitions made before him within a reasonable time, and that any failure in exercising this jurisdiction conferred upon him or reluctancy in acting in a time-bound manner would be a fit ground for the courts to engage in an exercise of judicial review of his actions, irrespective of the fact that it is the speaker who has the prerogative to adjudicate such petitions. It held that even where the jurisdiction of the courts to embark upon an examination on the merits of such prerogative powers has been ousted, the same does not curtail or inhibit the power of judicial review over the manner of exercise or non-exercise of such prerogative powers. Para 331. Similarly, in AG Peralevalan quoted Supra, this court rated that any inexplicable or inexcusable non-exercise of a prerogative or sovereign power would be amenable to judicial review, and that the manner of exercise of such powers by the governor could not be said to be impervious to judicial scrutiny. Para 332. From the above exposition of law, it becomes clear as a noonday that no exercise of power under the Constitution is beyond the pale of judicial review. Thus, we find no reason to exclude the discharge of functions by the governor or the president under Articles 200 and 201 of the Constitution, respectively. Para 333. It could be argued that the decision taken by the governor under Article 200 would be shielded from the scrutiny of the courts by virtue of the immunity accorded under Article 361 of the Constitution. However, in this regard, we may only refer to the observations made by this court in Rameshwar Prasad, quoted Supra, which leaves no doubt that the immunity enshrined in Article 361 of the Constitution does not preclude or prohibit the courts in any manner from looking into the actions of the governor, which by necessary implication would include his actions under Article 200 as well. The relevant observations are as follows. Para 173. A plain reading, quote, para 173. A plain reading of the aforesaid article shows that there is a complete bar to the impleading and issue of notice to the president or the governor, inasmuch as they are not answerable to any court for the exercise and performance of their powers and duties. Most of the actions are taken on the aid and advice of the Council of Ministers. Emphasis. The personal immunity from answerability provided in Article 361 does not bar the challenge that may be made to their actions. Under law, such actions, including those actions where the challenge may be based on the allegations of malafide, are required to be defended by the Union of India or the state, as the case may be. Even in cases where personal malafides are alleged and established, it would not be open to the governments to urge that the same cannot be satisfactorily answered because of the immunity granted. Emphasis ended. In such an eventuality, it is for the respondent defending the action to satisfy the court either on the basis of the material on record or even filing the affidavit of the person against whom such allegation of personal malafides are made. Ellipsis, end of quote, emphasis applied. Para 334. The High Court of Madras in S. Ramakrishnan versus State of Tamil Nadu reported in 2020 SCC Online, Madras 5207, was in season of a similar issue involving a bill passed by the State Legislative Assembly, which remained pending for 2 months before the governor for grant of assent. When the High Court posed a question as regards the inaction on the part of the governor, the Advocate General referred to Article 361 of the Constitution. The court interpreted Article 361 in light of Article 200 and observed that the protection granted to the governor under the Constitution was to perform his constitutional duties expeditiously. It also underscored the obligation of the courts to perform their constitutional duties and subjecting unconstitutional actions to judicial scrutiny in public interest. The relevant observations are as follows. Quote, Para 6. A perusal of Article 200 assent to bills would reveal that the constitutional authority has to take a decision if a bill is presented for assent as soon as possible. Emphasis. The the protection has been granted by the framers of the Constitution with hope and trust in the appointees that they would perform their constitutional functioning promptly and there would not be any situation wherein they would be called for to give explanation or they will be questioned by the court of law. End of emphasis. Para 7. When situation changes and present kind of situation arises, a different approach has to be taken by the courts in the interest of the public. It is well settled law that extraordinary situation requires extraordinary remedies. When public interest requires, this court has to do its constitutional duties and to address the situation. However, this court is of the opinion that such a situation would not arise to pass any order in this matter. End of quote. Emphasis applied. Para 335. Thus, what is discernible from above is that the discharge of functions by the President or the Governor as constitutional and formal heads is undoubtedly subject to judicial review by virtue of it being an exercise of their constitutional powers. However, could it at the same time be said that nevertheless it would be improper for the courts to examine such actions of the President or the Governor as the actions are essentially political in nature and hence non-justiciable for the reason that no judicial standard can be evolved for scrutiny of such actions. In this regard, we may make reference to certain decisions rendered by this court as well as few landmark decisions of other international jurisdictions. Para 336. In Minerva Mills versus Union of India, reported in 1980, Volume 3, SCC 625, this court held that the jurisdiction of courts is not ousted merely because a question has a political color. Every constitutional question, irrespective of the political complexion or make thereof, falls within the jurisdiction of the courts. The court held that whether the legislature or the executive has acted within the limits of its authority or not is for the courts to decide. The relevant observations are as follows. Quote, Para 98. Emphasis. It is axiomatic that if a question brought before the court is purely a political question not involving determination of any legal or constitutional right or obligation, the court would not entertain it since the court is concerned only with adjudication of legal rights and liabilities. But merely because a question has a political complexion, that by itself is no ground why the court should shrink from performing its duty under the Constitution if it raises an issue of constitutional determination. End of emphasis. There are a large number of decisions in the United States where the Supreme Court has entertained actions having a political complexion because they raised constitutional issues. Wide Gomelion versus Lightfoot, quoted in 364 US 339 of 1960, 5 L ed 2D 110, and Baker versus Carr 369 US 186 of 1962, 7 L ed 2D 663. Emphasis. The controversy before the court may be political in character, but so long as it involves determination of a constitutional question, the court cannot decline to entertain it. This is also the view taken by Gupta Justice and myself in State of Rajasthan versus Union of India, quoted in 1977, Volume 3, SCC 592, AIR 1977, SC 1361. I pointed out in my judgment in that case, and I still stand by it, that merely because a question has a political color, the court cannot fold its hands in despair and declare judicial hands off. So long as the question is whether an authority under the Constitution has acted within the limits of its power or exceeded it, it can certainly be decided by the court. Indeed, it would be constitutional obligation to do so. End of emphasis. I have said before, I repeat again that the Constitution is suprema lex, the paramount law of the land, and there is no department or branch of government above or beyond it. Every organ of government, be it the executive or the legislature or the judiciary, derives its authority from the Constitution, and it has to act within the limits of its authority, and whether it has done so or not is for the court to decide. The court is the ultimate interpreter of the Constitution, and when there is manifestly unauthorized exercise of power under the Constitution, it is the duty of the court to intervene. Let it not be forgotten that to this court, as much as to other branches of government, is committed the conservation and furtherance of constitutional values. The court's task is to identify those values in the constitutional plan and to work them into life in the cases that reach the court. Ellipsis. End of quote. Para 337. The 9-judge bench decision court in S.R. Bommai, quoted supra, observed that the concept of justiciability is not synonymous with judicial review. It noted that even while exercising power of judicial review, courts can decline to exercise such power as being non-justiciable. It categorically observed that though judicial review may be avoided on questions of political nature, yet legal questions camouflaged with a political cloak will be justiciable. The relevant observations have been reproduced herein below. Quote, Para 201. Judicial review must be distinguished from justiciability. Emphasis. The two concepts are not synonymous. The power of judicial review goes to the authority of the court, though in exercising the power of judicial review, the court in an appropriate case may decline to exercise the power as being not justiciable. The Constitution is both the source of power as well as it limits the power of an authority ex necessitate. The judiciary has to decide the source, extent, limitations of the power and legitimacy in some cases authority exercising the power. There are no hard and fast fixed rules as to justiciability of a controversy. End of emphasis. Ellipsis. Para 258. Justiciability is not a legal concept with a fixed content, nor is it susceptible of scientific verification. Its use is the result of many precious or variegated reasons. Justiciability may be looked at from the point of view of common sense limitation. Emphasis. Judicial review may be avoided on questions of purely political nature, though pure legal questions camouflaged by the political questions are always justiciable. End of emphasis. The courts must have judicially manageable standards to decide a particular controversy. Justiciability on a subjective satisfaction conferred in the widest terms to the political coordinate executive branch created by the constitutional scheme itself is one of the considerations to be kept in view in exercising judicial review. Ellipsis. End of quote. Emphasis applied. Para 338. This court in A.K. Kaul versus Union of India, reported in 1995, Volume 4, SCC 73, also elucidated the distinction between judicial review and justiciability. It observed that in a written constitution, the bounds within which the various organs of the state are delineated, the same implicitly casts a duty upon the courts to test the validity of every action of such constitutional organ through judicial review to ensure that such exercise of power is within the confines of the Constitution. It thus held that the power of judicial review of the courts would be available in respect of exercise of all powers by any authority under the Constitution unless expressly excluded. It further held that although judicial review is the norm, yet the unavailability of judicially manageable standards in certain aspects of the power whose exercise is in question may render the judicial review of such exercise of power non-justiciable. It explained that justiciability refers to the question whether a particular field could be said to fall within the purview of the power of judicial review. The relevant observations are as follows. Quote, Para 12. It is therefore necessary to deal with this question in the instant case. We may, in this context, point out that a distinction has to be made between judicial review and justiciability of a particular action. Emphasis. In a written constitution, the powers of the various organs of the state are limited by the provisions of the constitution. The extent of those limitations on the powers has to be determined on an interpretation of the relevant provisions of the constitution. Since the task of interpreting the provisions of the constitution is entrusted to the judiciary, it is vested with the power to test the validity of an action of every authority functioning under the constitution on the touchstone of the constitution in order to ensure that the authority exercising the power conferred by the constitution does not transgress the limitations placed by the constitution on exercise of that power. This power of judicial review is, therefore, implicit in a written constitution, and unless expressly excluded by a provision of the constitution, the power of judicial review is available in respect of exercise of powers under any of the provisions of the constitution. Justiciability relates to a particular field falling within the purview of the power of judicial review. End of emphasis. On account of want of judicially manageable standards, there may be matters which are not susceptible to the judicial process. Such matters are regarded as non-justiciable. In other words, during the course of exercise of the power of judicial review, it may be found that there are certain aspects of the exercise of that power which are not susceptible to judicial process on account of want of judicially manageable standards and are therefore not justiciable. End of quote. Emphasis supplied. Para 339. This quote in Epuru Sudhakar versus Government of AP reported in 2006, Volume 8, SCC 161, speaking in the context of Article 72 and 161 of the Constitution respectively, observed that the determining factor in deciding whether a sovereign or prerogative power would be subject to judicial review is the subject matter of such power and not its source. It held that the exercise of every prerogative power is subject to the rule of law, and the rule of law cannot be made subservient to political expediency. The court defined that manageable standards referred to certain discernible standards expected in a functioning democracy. It also held that exercise of any prerogative power cannot be placed in a straitjacket formula, and manageable standards would vary depending on the nature of the power. The relevant observations are as follows. Quote, Para 66. Granting of pardon is in no sense an overturning of a judgment of conviction, but rather it is an executive action that mitigates or sets aside the punishment for a crime. It eliminates the effect of conviction without addressing the defendant's guilt or innocence. Emphasis. The controlling factor in determining whether the exercise of prerogative power is subject to judicial review is not its source but its subject matter. It can no longer be said that prerogative power is ipso facto immune from judicial review. An undue exercise of this power is to be deplored. Considerations of religion, caste, or political loyalty are irrelevant and fraught with discrimination. These are prohibited grounds. The rule of law is the basis for evaluation of all decisions. The supreme quality of the rule of law is fairness and legal certainty. The principle of legality occupies a central plan in the rule of law. Every prerogative has to be subject to the rule of law. That rule cannot be compromised on the grounds of political expediency. To go by such considerations would be subversive of the fundamental principles of the rule of law, and it would amount to setting a dangerous precedent. The rule of law principle comprises a requirement of government according to law. The ethos of government according to law requires the prerogatives to be exercised in a manner which is consistent with the basic principle of fairness and certainty. End of emphasis. Therefore, the power of executive clemency is not only for the benefit of the convict, but while exercising such a power, the president or the governor, as the case may be, has to keep in mind the effect of his decision on the family of the victims, the society as a whole, and the precedent it sets for the future. End of quote, ellipsis. In conclusion, it may be stated that there is a clear symmetry between the constitutional rationale for review of statutory and prerogative power. In each case, the courts have to ensure that the authority which is consistent with the rule of law, which is the fundamental principle of good administration. In each case, the rule of law should be the overarching constitutional justification for judicial review. The exercise of prerogative power be placed in straitjacket formula, and the perceptions regarding the extent and amplitude of this power are bound to vary. However, when the impugned decision does not indicate any data or manageable standards, the decision amounts to derogation of an important constitutional principle of rule of law. End of quote, emphasis applied. Para 340. In Regina Miller versus Prime Minister, Lord Advocate and others intervening, reported in 2019, Volume 3, WLR 589, the Supreme Court of the United Kingdom was dealing with the justiciability of the power of prorogation. It was held that although the courts cannot decide political questions, yet, the fact that a dispute arises from a matter of political controversy would not restrain the courts completely from looking into it in exercise of judicial review. It further noted that almost all decisions by the executive have a political hue to them, yet the courts in the past have exercised a supervisory jurisdiction. The court held that a threat to parliamentary sovereignty constitutes as a significant ground for justiciability of prerogative powers. Para 341. In the seminal decision of Baker versus Carr, reported in 1962 SEC Online US SC 40, the Supreme Court of the United States of America examined whether questions of legislative apportionment were essentially political questions and hence non-justiciable. The court in this case laid down 6 heavily overlapping indicia of a non-justiciable matter. These were as follows. Number 1, a textually demonstrable constitutional commitment of the issue to another political branch. Or number 2, a lack of judicially discoverable and manageable standards for resolving it. Or number 3, a need to make an initial policy determination clearly for non-judicial discretion. Or number 4, the impossibility of a decision by the court without expressing lack of respect due to coordinate branches of government. Or number 5, an unusual need for unquestioning adherence to a political decision already made. Or number 6, the potentiality for embarrassment from multifarious pronouncements by various departments on one question. It was emphatically held that, save the aforesaid considerations, no other issue is liable for dismissal on ground of a lack of justice. Para 342. Before proceeding further, we deem it appropriate to refer to all the aforesaid decisions of this court where the justiciability assent has been discussed. The first in line is the Constitutional Bench decision in Kameshwar Singh, quoted Supra, and MC Mahajan Justice as where MC Mahajan Justice as his lordship then was in the context of Article 31A of the Constitution, observed that the assent of the President, once given to a bill reserved for his consideration, is non-justiciable. The relevant observations are as follows. Quote, Para 266, ellipsis followed by, the provisions of Article 31 Clause 2, therefore, do not stand repealed by Article 31A. On the other hand, they are kept alive. The difference is that persons whose properties fall within the definition of the expression estate in Article 31A are deprived of their remedy under Article 32 of the Constitution, and the President has been constituted the sole judge of deciding whether a state law acquiring estates under compulsory power has or has not complied with the provisions of Article 31 Clause 2. The validity of the law in those cases depends on the subjective opinion of the president and is not justiciable. Once the assent is given, the law is taken to have complied with the provisions of Article 31, Clause 2. End of emphasis, end of quote, emphasis applied. Para 343. The aforesaid observations would indicate that the grant of assent by the President to a state legislation falling under Article 31A was held to be non-justiciable only on the ground that the first proviso to Article 31A confers the power on the President to take a decision as regards whether assent is to be granted or not. Para 344. The next decision where the justiciability of an assent was discussed is the decision of three-judge bench in Hext quoted supra, wherein inter alia, one of the grounds of challenge to the legislation under consideration was that since the subject matter of the bill fell under at least 2 of the 7th schedule, there was no occasion for the governor to have reserved the bill for the consideration of the president. It is on this ground that the subsequent grant of assent by the president was called into question. Negativing the contention, the court observed thus, quote, Para 86. There is no provision in the Constitution which lays down that a bill which has been assented to by the President would be ineffective as an act if there was no compelling necessity for the governor to reserve it for the assent of the President. A bill which attracts Article 254, Clause 2 or Article 304, Subclause B, where it is introduced or moved in the Legislative Assembly of a state without the previous sanction of the President, or which attracted Article 31, Clause 3, as it was then in force, or falling under the second proviso to Article 200, has necessarily to be reserved for the consideration of the President. There may also be a bill passed by the state legislature where there may be a genuine doubt about the applicability of any of the provisions of the Constitution which require the assent of the President to be given to it in order that it may be effective as an act. In such a case, it is for the governor to exercise his discretion and to decide whether he should assent to the bill or should reserve it for consideration of the President to avoid any future complication. Even if it ultimately turns out that there was no necessity for the governor to have reserved a bill for the consideration of the President, still he having done so and obtained the assent of the President, the act so passed cannot be held to be unconstitutional on the ground of want of proper assent. This aspect of the matter, as the law now stands, is not open to scrutiny by the courts. In the instant case, the finance bill, which ultimately became the act in question, was a consolidating act relating to different subjects, and perhaps the governor felt that it was necessary to reserve it for the assent of the parliament. The president. We have no hesitation in holding that the assent of the president is not justiciable, and we cannot spell out any infirmity arising out of his decision to give such assent. End of emphasis, end of quote, emphasis applied. It is important to note that the aforesaid observations were made by this court in response to the argument that the grant of assent by the President in a case where it was not necessary for the governor to reserve the bill for the consideration of the President would vitiate the assent given by the President. On the contrary, the case at hand involves a totally different factual situation wherein the state government is aggrieved by the reservation of bills by the governor in exercise of his discretion and not in accordance with the aid and advice of the Council of Ministers. The further grievance of the petitioner is that such reservation of bills by the governor is not guided by constitutional principles but is impelled by lack of bona fides and political reasons. The applicability of the ratio laid down in the aforesaid decisions of Kameshwar Singh quoted supra and Hext quoted supra, and also the other decisions of this court as regards the questions of justiciability and judicial review would have to be decided keeping in mind the peculiar facts of the case at hand, which we have been called upon to deal with. Para 346. The decision in Hext quoted supra was referred to in the decision of this court in Bharat Sevashram Sangh versus State of Gujarat, reported in 1986, Volume 4, SCC 51, wherein one of the challenges to the validity of the legislation was that the bill had received conditional assent from the President, and such partial or conditional assent not being permissible under the Constitution was thus erroneous in law. While the court referred to the observations made in Hext supra, it also looked into the materials on record and arrived at a conclusion that there was no infirmity in the grant of assent by the President. Therefore, it cannot be said that the decision of the court was based on the non-justiciability of assent alone, as the court arrived at the finding after the actual satisfaction on the validity of assent upon a perusal of the relevant materials. The relevant observations are reproduced below. Quote, Para 6. The contention relating to the alleged invalidity of the assent given by the President is formulated by the learned counsel for the petitioners or appellants as thus. The bill was passed by the legislature of the state on February 15, 1973, and it was immediately thereafter forwarded to the governor for his assent. The governor reserved the bill for the consideration of the president under Article 200 of the Constitution, and the subsequent events, according to the learned counsel, showed that the president did not either give his assent or withheld his assent as contemplated under Article 201 of the Constitution, but he gave a qualified or conditional assent which was not contemplated under Article 201 of the Constitution. It is argued that since the President did not give absolute assent but only a qualified or conditional assent, the bill in question had not become a law. In reply to these averments in the petitions, the Undersecretary to the Government of Gujarat Education Department has stated in his counter affidavit that the bill was presented to the Governor of Gujarat after it was passed by the Assembly. The Governor of Gujarat reserved the bill for the consideration of the President under Article 200 of the Constitution, since he felt that in view of Clause 33 of the bill, which provided for taking over of the management of a school for a limited period in public interest, it was necessary to reserve the bill for the consideration of the President. Accordingly, the bill was referred to the President. At the meeting held in the Ministry of Home Affairs, Government of India on August 3, 1973 to discuss the bill, it was suggested by the representatives of the central government that the provisions of the bill which did not exclude institutions established or administered by the minorities from their scope were repugnant to Article 30 of the Constitution, and therefore the bill should be suitably amended. It was also suggested to the representatives of the state government that it would be better to carry out the requisite amendments by promulgating an ordinance. Accordingly, the draft of the ordinance, which was ultimately promulgated as Ordinance 6 of 1973, was forwarded for the instructions of the President under Article 213, Clause 1 of the Constitution. Thereafter, the draft of the ordinance and the bill were both considered by the President, and he assented to the said bill and issued instructions as required by the proviso to Article 213 of the Constitution for the promulgation of the said ordinance on September 28, 1973. Accordingly, the said bill became law on its publication on the very same day. The ordinance was issued in September 29, 1973. In the circumstances, it cannot be said that the assent which was given by the President was conditional. The records relating to the above proceedings were also made available to the court. On going through the material placed before us, we are satisfied that the President had given assent to the Act, and it is not correct to say that it was a qualified assent. The Act, which was duly published in the official Gazette, contains the recital that the said Act had received the assent of the President on September 28, 1973. Moreover, questions relating to the fact whether assent is given by the Governor or the President cannot be agitated also in this manner. End of emphasis, end of quote, emphasis applied. Para 347. Hext quoted supra was also referred to and relied upon by this court in B.K. Pavitra quoted supra, wherein it was observed that owing to the sovereign nature of the power of the governor to reserve a bill for the consideration of the President under Article 200, it would not be possible for this court to reflect upon the situations in which such a power of reference may be exercised by the governor. It was further observed by the court that the decision in Hext quoted supra has excluded the exercise of this power from the scope of judicial scrutiny. The relevant observations read as under quote. Para 71 ellipsis followed by the eventuality which is specified in Article 254 Clause 2 does not exhaust the ambit of the power entrusted to the Governor under Article 200 to reserve a bill for the consideration of the President. Apart from a repugnancy in matters falling in the concurrent list between state and parliamentary legislation, a Governor may have sound constitutional reasons to reserve a bill for the consideration of the President. Article 200, in its second proviso, mandates that a bill which derogates from the powers of the High Court must be reserved for the consideration of the President. Apart from bills which fall within the description set out in the second proviso, the Governor may legitimately refer a bill for consideration of the President upon entertaining a legitimate doubt about the validity of the law. By its very nature, it would not be possible for this court to reflect upon the situations in which the power under Article 200 can be exercised. This was noticed in the judgment of this court in Hext. Hext Pharmaceuticals Limited versus State of Bihar, 1983, Volume 4, SCC 45, 1983, SCC, Tax 248, ellipsis, para 72. Hext in Hext Pharmaceuticals Limited versus State of Bihar, 1983, 4 SCC 45, 1983 SCC, Tax 248. Hext is an authority for the proposition that the assent of the president is non-justiciable. Hext also lays down that even if, as it turns out, it was not necessary for the governor to reserve a bill for the consideration of the president, if sorry, yet if it was reserved for and received the assent of the president, the law as enacted cannot be regarded as unconstitutional for want of proper assent. End of emphasis. Para 73. The above decisions essentially answer the submissions which were urged by Dr. Dhawan. The law, as propounded in the line of precedents adverted to above, must negate the submissions which were urged on behalf of the petitioners. Once the bill which led to the Reservation Act 2018 was reserved by the governor for the consideration of the president, it was for the president to either grant or withhold assent to the bill. The president having assented to the bill, the requirements of Article 201 were fulfilled. The validity of the assent by the president is non-justiciable. End of emphasis, end of ellipsis, and then end of quote. Emphasis supplied. Para 348. We find it difficult to express our agreement with the view taken in B.K. Pavitra, quoted supra, that the exercise of power to reserve a bill for the consideration of the president by the governor is beyond the pale of judicial scrutiny, even in cases where it is exercised in his own discretion and against the aid and advice of the Council of Ministers. We have discussed in the previous sections of this judgment that the governor, under Article 200, is ordinarily expected to act in accordance with the aid and advice of the Council of Ministers, and it is only in certain very exceptional situations that he should resort to the exercise of discretion. Further, the limits of such discretion are to be derived from Article 163, Clause 1. The exercise of such discretion by the governor, if excluded from judicial scrutiny, would militate against the fundamental constitutional principle that exercise of all power must be within the confines of the Constitution. Absolute exclusion of judicial scrutiny would also confer upon the governor an absolute power to disregard the will of the people expressed through the state legislature and government. While it is true that there may be situations in which the exercise of discretion by the governor under Article 200 would be permissible, this does not imply that this court would be precluded from determining the legality and propriety of the exercise of such discretion in a given case. In fact, it is owing to the impossibility of the task of exhaustively charting out such situations wherein discretion would be allowed to be exercised that it becomes all the more crucial for the power of judicial review to exist with the courts. This would keep in line any bona fide action on the part of the governor which is disguised under the garb of legitimate exercise of discretion. Para 349. The twofold observations in B.K. Pavitra, quoted supra, vesting the governor with unfettered discretion to reserve bills for the consideration of the president under Article 200, and at the same time excluding such exercise of discretion from judicial scrutiny, essentially has the effect of safeguarding the actions of the governor in a lead casket which cannot be permeated even in cases of breach of the constitutional framework within which the governor is expected to function. Para 350. The Constitution Bench in Kesari Hind, quoted supra, had the occasion to consider in detail whether the assent of the President sought with regard to a state law would be limited only to the repugnancy of the laws to which the attention of the President was drawn to while seeking his assent, or would such assent be qua all other laws enacted by the Parliament to which the state law in question may also be repugnant to. In other words, whether the assent granted by the President to a state legislation would be deemed to be an assent qua all earlier enactments made by the Parliament on the subject. This court, while answering the aforesaid question in the negative, held that the consideration by the President and his assent under Article 254, Clause 2 is limited to the proposal made by the state government, and the state legislation would prevail only qua the laws for which repugnancy was pointed out and the assent of the President was sought for. The court, inter alia, held that the words reserved for consideration indicate the requirement of an active application of mind by the president to the repugnancy pointed out between the proposed state law and the earlier law made by the parliament, and the necessity of having such a law in the state, keeping in mind the peculiar facts, the attending circumstances, and the backdrop in which such law was made by the state government. Similarly, the word consideration indicates the requirement of careful thinking and due application of mind regarding the necessity of having a state law which is repugnant to the laws made by the parliament. Lastly, the term assent implies an expressed agreement of mind to what is proposed by the state, that is, knowledge of the president as to the repugnancy between the state law and the earlier laws made by parliament on the same subject matter, as well as agreement to the reason and attending circumstances regarding the necessity of having such state law. 300 and para 351. As regards justiciability, it was held by the court that the examination of the records to ascertain the extent to which assent was sought for would not amount to deciding whether assent was rightly or wrongly given. Thus, it could not be said that the court was determining the validity of the assent granted by the president. The relevant observations made by M.B. Shah, Justice, speaking for the majority, are reproduced below. Quote, para 25. In our view, for finding out whether the assent was given qua the repugnancy between the state legislation and the earlier law made by parliament, there is no question of deciding validity of such assent, nor the assent is subjected to any judicial review. That is to say, merely looking at the record for which assent was sought would not mean that the court is deciding whether the assent is rightly, wrongly, or erroneously granted. The consideration by the court is limited to the extent that whether the state has sought assent qua particular earlier law or laws made by parliament prevailing in the state, or it has sought general assent. In such case, the court is not required to decide the validity of the assent granted by the president. In the present case, the assent was given after considering the extent and nature of repugnancy between the Bombay Rent Act and the Transfer of Property Act, as well as the Presidency Small Cause Courts Act. Therefore, it would be totally unjustified to hold that once the assent is granted by the president, the state law would prevail qua earlier other law enacted by parliament for which no assent was sought for, nor which was reserved for the consideration of the president. Ellipsis, para 29. We further make it clear that granting of assent under Article 254, Clause 2 is not exercise of legislative power of the President, such as contemplated under Article 123, but is part of the legislative procedure. Whether procedure prescribed by the Constitution before enacting the law is followed or not can always be looked into by the court. End of emphasis, end of quote, emphasis applied. Para 352. Doraiswamy Raju, Justice, in a concurring opinion, laid strong emphasis on the requirement that a reference to the President for the purpose of Article 254, Clause 2 must be precise and specific as regards the extent of protection sought for the state legislation. He observed that, keeping in mind the serious implications of the grant of the assent of the president to a repugnant state law, the making of such reference to the president cannot be exercised in a routine manner. He further observed that the non-justiciability of the assent of the president would not preclude the constitutional courts from examining the sufficiency and justifiability of a predominance sought for the state legislation over the central legislation. The relevant observations are reproduced below. Quote, para 72, ellipsis followed by. The exception engraved in Clause 2 to enable the state law to prevail in that state, the legislature of which has enacted it, notwithstanding its repugnancy as above, as long as both the laws deal with the concurrent subject, will inure to its benefit if it has been reserved for the consideration of the President and has received his assent under the said provision of the Constitution of India. Thus, the sweep of mandate and serious nature of the result flowing from the assent renders, in my view, the very exercise of power by the President and the attendant formalities whereof as of great significance and vitally important, and not a mere routine or mechanical exercise. Despite such assent having been obtained, power of Parliament to enact at any time any law with respect to the same matter, including a law adding to, amending, varying, or repealing the law so made by the legislature of the state, with the assent envisaged under Clause 2 of Article 254, has also been conserved and preserved in the proviso to the said clause. In substance, Parliament has undisputed power to undo the effect or consequences flowing from the presidential assent obtained under Clause 2 by enacting a subsequent law, creating once more a repugnancy, thereby override or repeal impliedly to the extent of such repugnancy the state law. Para 73. The assent of the President envisaged under Article 254, Clause 2 is neither an idle or empty formality nor an automatic event necessitated or to be given for the mere asking in whatever form or manner and whether specific, vague, general, or indefinite. In the terms sought for, to claim that once sought and obtained as well as published, a curtain or veil is drawn to preclude any probe or contention for consideration that what was sought and obtained was not really what should and ought to have been, to claim the protection envisaged under Clause 2 in respect of a particular state law vis-a-vis or with reference to any particular or specified law on the same subject made by Parliament or an existing law in force. The repugnancy envisaged under Clause 1 or enabled under Clause 2 to get accepted from under the protective coverage of the assent obtained from the President is such that there is a legislation or legislative provisions covering and operating on the same field or identical subject matter made by both the Union and the State, both of them being competent to enact in respect of the same subject matter or legislative field, but the legislation by Parliament has come to occupy the entire field. Necessarily in the quasi-federal structure adopted for the nation, predominance is given to the law made by Parliament, and in such circumstances, only the state law which secured the assent of the President under Clause 2 of Article 254 comes to be protected, subject of course to the powers of Parliament under the proviso to the said clause. Emphasis. Therefore, the President has to be apprised of the reasons, at least as to why his assent is being sought, the need or necessity, and the justification or otherwise for claiming predominance for the state law concerned. This itself would postulate an obligation inherent in the scheme underlying as well as the very purpose and object of seeking the assent under Clause 2 of Article 254 to enumerate or specify and illustrate the particular central law or provision with reference to which the predominance is desired. The absence of any standardized or stipulated form in which it is to be sought for should not detract the state concerned to disown its obligation to be precise and specific in the extent of protection sought, having regard to the serious consequences which thereby inevitably follow, that is, the substitution of the union law in force by the state law in the territorial limits of the state concerned, with drastic alteration or change in the rights of citizen which it may thereby bring about. Para 74. The mere forwarding of a copy of the bill may obviate, if at all, only the need to refer to each one of the provisions therein in detail in the requisition sent or the letter forwarding it, but not obliterate the necessity to point out specifically the particular central law or provisions with reference to which the predominance is claimed or purported to be claimed. The deliberate use of the word consideration in Clause 2 of Article 254, in my view, not only connotes that there should be an active application of mind, but also postulates a deliberate and careful thought process before taking a decision to accord or not to accord the assent sought for. End of emphasis. If the object of referring the state law for consideration is to have the repugnancy resolved by securing predominance to the state law, the President has to necessarily consider the nature and extent of repugnancy, the feasibility, practicalities, and desirabilities involved therein, though may not be obliged to write a judgment in the same manner the courts of law do before arriving at a conclusion to grant or refuse to grant, or even grant partially if the repugnancy is with reference to more than one law in force made by Parliament. Protection cannot be claimed for the state law when questioned before courts, taking cover under the assent, merely asserting that it was in general form, irrespective of the actual fact, whether the state law claimed for such protection against a specific law or the attention of the president was invited to at least an apprehended repugnancy vis-a-vis the particular central law. In the teeth of innumerable central laws enacted and enforced on concurrent subjects enumerated in List 3 of the 7th Schedule to the Constitution and the hoard of provisions contained therein, artificial assumptions based on some supposed knowledge of all those provisions and the presumed regularity of official acts cannot be blown out of proportion to do away with an essential exercise to make the assent meaningful, as if they are empty formalities, except at the risk of rendering Article 254 itself a dead letter or merely otiose. The significant and serious alteration in or modification of the rights of parties, both individuals or institutions, resulting from the assent cannot be overlooked or lightly brushed aside as of no significance whatsoever. In a federal structure peculiar to the one adopted by our constitution, it would become necessary for the president to be apprised of the reason as to why and for what special reason or object and purpose predominance for the state law over the central law is sought, deviating from the law in force made by parliament for the entire country, including that part of the state. When this court observed in Gram Panchayat of village Jamalpur versus Malvinder Singh, quoted in 1985, Volume 3, SCC 661, when this court observed in Gram Panchayat of village Jamalpur versus Malvinder Singh that when the assent of the president is sought for a specific purpose, the efficacy of the assent would be limited to that purpose and cannot be extended beyond it, and that if the assent is sought and given in general terms so as to be effective for all purposes, different considerations may legitimately arise. It cannot legitimately be contended that this court had also declared that reservation of state law can also be by mere reference to Article 254, Clause 2 alone, with no further disclosures to be made, or that with mere forwarding of the bill, no other information or detail was either a permissible or legalized and approved course to be adopted, or that such course was held to be sufficient by this court to serve the purpose of the said article. The expression general terms needs to be understood, in my view, a reference to a particular law as a whole in contrast to any one particular or individual in the said law, and not that it can be even without any reference whatsoever. The further observation therein, quoted in SCC, page 669, para 12, quote, not only was the president not apprised in the instant case that his assent was sought because of the repugnancy between the State Act and the pre-existing Central Act on the vesting of evacuee properties, but his assent was sought for a different specific purpose altogether, end of quote, would belie any such claim. Per contra, it would only reinforce the principle that the consideration as well as the decision to accord consent should be a conscious one after due application of mind, relevant and necessary for the purpose. Though submission of a thesis on the various aspects of repugnancy involved may not be the requirement, the reservation for consideration would necessarily obligate an invitation of the attention of the president as to which of the pre-existing central enactments or which provisions of those enactments are considered or apprehended to be repugnant, with reference to which the assent envisaged in Article 254, Clause 2 is sought for. This becomes more necessary also for the reason that the repugnancy in respect of which predominance is sought to be secured must be shown to exist or apprehended on the date of the state law, not in a vacuum to cure any and every possible repugnancy in respect of all laws, irrespective of whether it was in the contemplation or not of the seeker of the assent or of the president at the time of consideration for according assent. Para 75, emphasis. This court has, no doubt, held that the assent accorded by the president is not justiciable, and courts cannot spell out any infirmity in the decision arrived at to give the assent. Similarly, when the president was found to have accorded assent and the same was duly published, it cannot be contended that the assent was not really that of the president as claimed. It is also not given to anyone to challenge the decision of the president according assent on merits and as to its legality, propriety or desirability. But that is not the same thing as approving an attempt to draw a blanket or veil so as to preclude an examination by this court or the High Court as to the justifiability and sufficiency or otherwise or the of the protection or predominance claimed for the state law over the law made by parliament or the existing law based upon the assent accorded, resulting at times in substantial alteration, change or modification in the rights and obligations of citizen, including the fundamental rights. When the Constitution extends a form of protection to a repugnant state law, permitting predominance and also to hold the field in the place of the law made by the center, conditioned upon the reservation of the state law for the consideration of the president and obtaining his assent, it is to be necessarily viewed as an essential prerequisite to be effectively and meticulously fulfilled before ever availing of the protection, and the same cannot be viewed merely as a ceremonial ritual. If such a vitally essential procedure and safeguard is to be merely viewed as a routine formality which can be observed in whatever manner decided by those concerned, and that it would be merely enough if the if the assent has been secured, if the assent has been secured, howsoever obtained, it would amount to belittling its very importance in the context of distribution of legislative powers and the absolute necessity to preserve the supremacy of Parliament to enact a law on a concurrent topic in List 3 for the entire country. It would also amount to acceptance of even a farce of compliance to be actual or real compliance. Such a course could not be adopted by courts except by doing violence to the language as well as the scheme and the very object underlying Article 254, Clause 2, Para 76. Different provisions of the Constitution envisage the grant of assent by the President as well as the Governor of a state. Article 111 provides for the assent of the President to a bill passed by the Houses of Parliament in the same manner in which Article 200 empowers the Governor of a state in respect of a bill passed by the Legislative Assembly or by the Houses of the Legislature where there is a Legislative Council in addition to the Assembly. Parliament for the Union consists of the President and two houses, as the legislature of states consists of the governor and the house or houses, as the case may be. Wide Articles 78 and 79 and 168. The policy-making executive power of the Union also vests with the President, as the executive power of the state vests with the Governor, and those powers have to be exercised with the aid and advice of the Council of Ministers for the Union headed by the Prime Minister and for the state to be headed by the Chief Minister. The President or the Governor, as the case may be, as and when a bill after having been passed is presented, may accord assent or as soon as possible thereafter return the bill to the Houses with a message requesting to reconsider the bill or any provisions thereof, including the introduction of any amendment as recommended in his message, and if thereafter the Houses on reconsideration of the bill pass the bill again with or without amendment and present the same for the assent, the President or Governor, as the case may be, shall not withhold his assent. Being an exercise pertaining to expression of political will, apparently the will of the people expressed through the legislation passed by their elected representatives is given prominence by specifically providing for a compulsory consent or assent. The same could not be said with reference to the assent of President envisaged under Articles 31A, 31C, 254, Clause 2 and 304 subclause B of the Constitution. In my view, the assent envisaged in these articles by the very nature and character of the powers conferred constitute a distinct class and category different from the normal assent envisaged under Articles 111 of the President or Article 200 of the Governor. Article 201 also indicate that even when for the second time the houses of the state legislature pass the bill and present for consideration, there is no compulsion for the President to accord assent. Therefore, the reservation of any bill or act for the consideration of the President for according his assent, keeping in view also the above object envisaged under Article 254 Clause 2, renders it qualitatively different from the ordinary assent to be given by the President to a bill passed by Parliament or that of the Governor to a bill passed by the legislatures of the state concerned. Para 77. The assent of the President or the Governor, as the case may be, is considered to be part of the legislative process only for the limited purpose. The legislative process is incomplete without them for enacting a law, and in the absence of the assent, the bill passed could not be considered to be an act or a piece of legislation, effective and enforceable, and not to extend the immunity in respect of procedural formalities to be observed inside the respective houses, and certification by the presiding officer concerned of their due compliance to areas or acts outside and besides those formalities. The powers actually exercised by the President at any rate under Articles 31A, 31C, 254, Clause 2, and 304, Subclause B are a special constituent power vested with the head of the Union as the protector and defender of the Constitution and safety valve to safeguard the fundamental rights of citizens and federal structure of the country's polity as adopted the Constitution. A genuine, real, and effective consideration would depend upon specific and sufficient information being provided to him, inviting at any rate his attention to the central law with which the state law is considered or apprehended to be repugnant, and in the absence of any effort or exercise shown to have been undertaken when questioned before courts, the state law cannot be permitted or allowed to have predominance or an overriding effect over that central enactment of parliament to which no specific reference of the president at all has been invited to. This, in my view, is a must and an essential requirement to be satisfied, in the absence of which the consideration claimed would be one in a vacuum and really oblivious to the horde of legislations falling under the concurrent list in force in the country and enacted by Parliament. To uphold as valid the claim for any such blanket assent or all-round predominance over any and every such law, whether brought to the notice of the President or not, would amount to legitimization of what was not even in the contemplation or consideration on the basis of some assumed consideration. In order to find out the real state of affairs as to whether the assent in a given case was after a due and proper application of mind and effective consideration as envisaged by the Constitution, this court as well as the High Court exercising powers of judicial review are entitled to call for the relevant records and look into the same. This the courts have been doing as and when considered necessary all along. No exception, therefore, could be taken to the High Court in this case adopting such a procedure in discharge of its obligations and exercise of jurisdiction under the Constitution of India. End of quote. Emphasis supplied. Para 353. It is pertinent to note that it was observed by Doraswamy Justice that the assent of the President under Article 254, Clause 2 is not of the same nature as the assent of the President or the Governor under Article 111 and 200 of the Constitution, respectively. He placed strong emphasis on the use of the expression consideration in Article 254, Clause 2, to hold that such a consideration by the President would be meaningless in the absence of a clear and specific reference made to him, pointing out the repugnancy between the central law and the proposed state law. Para 354. While the observations made in Kaisari Hind Supra as regards the import of the expression consideration were in the context of Article 254, Clause 2, the same would apply to every bill reserved for the consideration of the President under Article 201, as the expression consideration finds a mention in Article 201 as well. Thus, the reservation for the consideration of the President must be accompanied by a reference which contains specific details as regards the purpose why the consideration of the President is sought. Para 355. The reason why this court in Kesari Hind quoted Supra insisted that the requirement of delineating the reasons necessitating the reservation of a bill by the governor rests upon the state government is because it is the state through its council of ministers who are objectively better equipped in doing so, by virtue of the fact that the genesis of such bills is normally spearheaded by the council of ministers. Their close involvement in the deliberations that culminated in the bill, their crucial role as part of the members of the House of Legislature, and them being reposed with the responsibility of overall governance and well-being of the state, provides them the necessary expertise to assign robust reasons in making a reference. The State Council of Ministers being uniquely positioned to understand the legislative requirements of the state, the policy imperatives prevailing therein, and the socio-economic conditions demanding redressal can better voice the reasons that ought to accompany such a reference which the governor otherwise may not be capable of reasonably and comprehensively ascertaining, if not for the aid and advice of the Council of Ministers. Para 356. It is in this background that we are of the view that the governor would be duty bound to give careful deference to the aid and advice of the State Council of Ministers, and only in the limited cases of exceptional circumstances may he deviate from such advice tendered to him, subject to the reference being in tune with the aforesaid principles enunciated in the preceding paragraphs. Para 357. We have given some thought to the observations made in the aforesaid decisions as regards the non-justiciability of the assent of the President. As per the settled principles of parliamentary democracy across the world, the grant of assent to legislations is construed as a power of the head of the state, which is to be exercised only upon the aid and advice of the Council of Ministers. As per Article 74, Clause 2, and 163, Clause 3 of the Constitution, respectively, the question whether any, and if so, what advice was tendered by the ministers to the President or the Governor shall not be inquired into by any court. A perusal of Articles 111, 200, and 201, respectively, makes it clear that no reasons are required to be provided by the President or the Governor for according assent to bills. However, if the President or the Governor exercise the option of withholding of assent under Article 111 or 200, respectively, then there is a requirement to communicate the reasons for such withholding in the form of a message to the House or Houses of the Legislature. Similarly, as has been discussed with great emphasis in Kesari Hind Supra, if there is any reservation of bills for the consideration of the President by the Governor, then the same must be reflected by way of a specific and clear reference providing details as to why the reservation has been made, so as to enable the President to consider the desirability of according assent to the bill so reserved. Para 358. The grant of assent to a bill is an exercise which generally takes place on the aid and advice of the Council of Ministers, and assenting to the bill is the only practically possible course of action available to the constitutional heads in most of the common law jurisdictions. The grant of assent may not be justiciable because there exists an unavailability of any material upon which the courts may be able to undertake a judicial scrutiny. However, the same would not be the case as regards the withholding of assent or reservation of the bill for the consideration of the President, which can only be exercised upon furnishing of detailed reasons for the same. Para 359. The majority opinion of the court in Kesari Hind Supra held that the legislative procedure to be followed before the enactment of a legislation would always be amenable to judicial review, and thus it would be open to the courts to examine the reference which is made by the state government to the President seeking his assent. Applying the same logic, it could be said that the reservation of bills by the Governor for the consideration of the President is also part of legislative procedure, and thus the courts would not be precluded from examining such reference to determine its legality and its constitutional veracity. Para 360. In the Canadian decision in Galati, quoted supra, the grant of royal assent to a bill was held as non-justiciable on the ground of separation of powers, the grant of assent having been characterized as a legislative act. However, it must be kept in mind that the characterization of the grant of assent as a legislative act was in the context of the well-settled constitutional convention of a responsible government that assent must be granted in accordance with the advice of the Prime Minister. Further, as we have discussed in the preceding paragraphs, it is not the source of power, but the contents thereof, which determine the scope of judicial review under the Constitution. Para 361. On the contrary, Anne Toomey writes that in cases where a constitution is prescriptive and a constitutional breach is involved, a court is more likely to hold the breach to be justiciable issue, even if it relates to the grant of assent to a bill. She refers to the opinion of Millhouse Justice in Re Constitutional Reference number 1 of 2008, reported in 2009, volume 1, LRC 453, which held that where a country has a written constitution, the courts always have the jurisdiction to remedy branches of the courts always have the jurisdiction to remedy breaches of the Constitution. The said decision was also accepted by the Court of Appeal of Vanuatu in Republic of Vanuatu versus Carcasses, reported in 2010, Volume 2, LRC 264, which held that while a court will not otherwise inquire into or adjudicate upon issues arising in Parliament, it would be empowered to interpret and determine whether there has been a breach of a constitutional right. Para 362. As described in Kesari Hind, quoted Supra, the role of the President under Article 201 is a sui generis one, tailor made to fit the quasi federal constitutional scheme. The role of the Governor in reserving bills for the consideration of the President is also intrinsically linked with this constituent role of the President. It was also observed that the grant of assent is considered a legislative act only for the limited purpose that without it a bill cannot become law, and also for extending immunity to certain formalities to be followed within the legislature. This immunity does not extend to other aspects of the legal procedure which fall beyond the ambit of these of these limited formalities. Thus, compliance with the prescribed legislative procedure leading up to assent is open to judicial scrutiny in appropriate cases. Further, as we have discussed in the preceding paragraphs, the reservation of bills for the consideration of the President by the Governor is warranted only in certain limited situations. Para 363. The observations in the aforesaid decisions as regards the non-justiciability of the assent of the President under Article 201 cannot be construed to mean that the withholding of assent and reservation of bills by the Governor under Article 200 as well as withholding of assent by the President under Article 201 are beyond the scope of judicial review. The observations of non-justiciability of assent of the President under Article 201 can be explained in light of the assent under Article 201 being predominantly a matter of federal policy of the Union government on certain subject matters prescribed in various provisions of the Constitution, and on subject matters falling in the concurrent list, the Constitution has accorded primacy to the center over the states. On issues of repugnancy, for illustration, it is only on the approval of the President that a state law which is repugnant to a central legislation can become enforceable. No obligation is placed on the President to grant assent under Article 201, and it is to be decided by the President on the aid and advice of the Union Council for Ministers. It is in view of this position and for the limited extent of judicially manageable standards of evaluation that the assent under Article 201 has been described as non-justiciable. Para 364. However, the same is not the case when the courts have to consider the withholding of assent or reservation of bills by the Governor under Article 200. Our discussion on the scope of discretion available to the Governor makes it clear that the Governor exercises discretion in a very limited domain when discharging his functions under Article 200. He may reserve the bills for the consideration of the President only for achieving certain predetermined purposes, and his personal views, disliking for the policy or the views of the Union government are not grounds on which he may reserve a bill under Article 200. The nature of constitutional function prescribed for the Governor under Article 200 being such, the exercise of such function can be subjected to judicial review on the standard of being within constitutional bounds. Reserving a bill for the consideration of the President is a part of the legislative procedure and must invariably be subjected to judicial review in cases where the constitutionally prescribed procedure is not complied with or misused. Para 365. The discharge of functions by the President under Article 201 stands on a different footing than that of the Governor under Article 200. While there is no political hue to the limited discretion conferred upon the Governor under Article 200, and any exercise of such discretion has to be solely on constitutional grounds, the grant of assent under Article 201 has an element of political hue by virtue of the fact that the President under Article 201 has been given the prerogative to decide whether the grant of assent in certain cases would be desirable or not. However, at the same time, what must be remembered is that it is only in those areas where the primacy has been given to the Union would this political consideration be permissible. Additionally, this political hue is not owing to the difference in opinion or political views of the governments at the center and the state, but is attributable to the desirability of vesting the Union government to exercise certain discretion in matters pertaining to broader issues where uniformity in national policy may be desirable. In such a case, the scope of justiciability under Article 201 would be limited to questions of arbitrariness, malfeasance, and inaction. 366. As a logical sequitur of the above, any exercise of Article 201 in a manner which does not align with this fundamental object underlying Article 201 would be liable to a greater degree of judicial scrutiny. Thus, wherever a bill which falls within the exclusive domain of the state legislature is being referred to the President for his consideration on the ground that it attracts one of the exceptional situations where the governor may exercise his discretion as mentioned in paragraph 300 of this judgment, it would not be open to the President to withhold assent without ascribing reasons as regards the doubt raised by the governor to such a bill. In such a case, the ideal course for the President would be to obtain legal opinion as regards the bill in appropriate cases by making reference to this court under Article 143 and only thereafter declare the grant or withholding of assent. Where the grounds of withholding of assent are not concerned with policy areas in which the union has primacy, the courts would have a greater degree of judicial scrutiny. We say this because on questions of legality, it is the constitutional courts which have been conferred with the power of arriving at a final decision, and the object of Article 201 is not to thwart the legislative procedure of the states by withholding of assent, even in areas falling within the exclusive domain of the states on grounds of legality. Para 367. We summarize our findings on the judicial review of the exercise of power by the governor under Article 200 and by the President under Article 201 of the Constitution as follows. Where the governor, item A, where the governor reserves a bill for the consideration of the President in his own discretion and contrary to the aid and advice tendered to him by the State Council of Ministers, it shall be open to the state government to assail such an action before the appropriate High Court or this court. Such a challenge can broadly be made on the following grounds. Number one, where the reservation is on the ground that the bill is of a description falling under the second proviso to Article 200 of the Constitution, it may be assailed on the ground that the bill or any provision thereof does not so derogate from the powers of the High Court so as to endanger the position which that court is designed by the Constitution to fill. The governor, while reserving a bill on this count, shall be expected to provide clear reasons and also point to the specific provisions of the bill which, in his opinion, attract the second proviso. This question, being purely of a legal nature, would be completely justiciable, and the competent court would be, after proper adjudication, fully authorized to approve or disapprove of such reservation by the governor. If such a challenge finds favor with the competent court, then subject to any other considerations, it would be a fit case for the issuance of a writ in the nature of mandamus to the governor for appropriate action. If, however, the challenge should fail, then the mechanism envisaged under Article 201 of the Constitution will spring into action. Number two, where the reservation is on account of the bill attracting any provision of the Constitution wherein the assent of the President is a condition precedent for the proper enactment and enforceability of such a bill as a law, such as under Article 364A2, or for the purpose of securing any immunity, such as under Article 31A, or overcoming any repugnancy that may exist qua a central legislation under Article 254. Clause 2, then the governor is expected to make a specific and clear reference to the President, properly indicating the reasons for such reservation and inviting his attention as described in Kesari Hind Supra. Such a reservation can be assailed by the state government if the reference made by the governor either fails to indicate the reasons for such reservation as discovered above, or that the reasons indicated are wholly irrelevant, malified, arbitrary, unnecessary, or motivated by extraneous considerations. Then such a reservation would be liable to be set aside. This question being purely of a legal nature would be completely justiciable, and the competent court would be, after proper adjudication, fully authorized to approve or disapprove of such reservation by the governor. If such a challenge finds favor with the competent court, then subject to any other considerations, it would be fit case for issuance of a writ in the nature of mandamus to the governor for appropriate action. If, however, the challenge should fail, then the mechanism envisaged under Article 201 of the Constitution will spring into action. Number three, where the reservation of a bill by the governor for the consideration of the president is on grounds of peril to democracy or democratic principles or on other exceptional grounds as mentioned in MP Special Police quoted Supra and Nabam Rebia quoted Supra, then the governor would be expected to make a specific and clear reference to the president, properly indicating the reasons for entertaining such a belief by pinpointing the specific provisions in this regard and the consequent effect that may ensue if such a bill were to be allowed to become a law. The governor, while making such a reference, should also indicate his subjective satisfaction as to why the aforesaid consequences that may ensue cannot be possibly curtailed or contained by taking recourse to the constitutional courts of the country. It shall be open to the state government to challenge such a reservation on the ground of failure on part of the governor to furnish the necessary reasons as discussed aforesaid, or that the reasons indicated are wholly irrelevant, malified, arbitrary, unnecessary, or motivated by extraneous considerations. This being a question completely capable of being determined by the constitutional courts, would be fully justifiable. Number four, reservation of a bill on grounds other than the ones mentioned above, such as personal dissatisfaction of the governor, political expediency, or any other extraneous or relevant considerations, is strictly impermissible by the Constitution and would be liable to be set aside forthwith on that ground alone. This will also encompass reservation of a bill by the governor after having already exercised the option of withholding of assent in terms of Article 200, except in such exceptional circumstance as mentioned in paragraph 204 of this judgment. Number four, where the governor exhibits inaction in making a decision when a bill is presented to him for assent under Article 200, and such inaction exceeds the time limit as has been prescribed by us in paragraph 250 of this judgment, then it shall be open to the state government to seek a writ of mandamus from a competent court against the governor directing expeditious decision on the concerned bill as is the mandate of the Constitution. However, it is clarified that the governor may successfully resist such a challenge on providing sufficient explanation for the delay caused. Section B, where the governor reserves a bill for the consideration of the president and the president in turn withholds assent thereto, then it shall be open to the state government to assail such an action before this court. Such a challenge can broadly be made on the following grounds. Number one, where a state bill has been reserved by the governor for the consideration of the president on the ground that assent of the president is required for the purpose of making the bill enforceable or securing some immunity therefore, then in such cases the withholding of assent by the president would be justiciable to the limited extent of exercise of such power in an arbitrary or modified manner. Owing to the political nature of the assent of the president in these categories of bills, the courts would impose a self-restraint. Number two, where a state bill has been reserved by the governor in his discretion for the consideration of the president on the ground that the bill appears to be patently unconstitutional for placing the principles of representative democracy in peril, the withholding of assent by the president would, in ordinary circumstances, involve purely legal and constitutional questions and therefore be justiciable without any impediments imposed by the doctrine of political ticket. In such cases, it would be prudent for the President to obtain the advisory opinion of this court by way of a reference under Article 143 and act in accordance with the same to dispel any apprehensions of bias, arbitrariness, or malefides. Number three, where the President exhibits inaction in making a decision when a bill is presented to him for assent under Article 201, and such inaction exceeds the time limit as has been prescribed by us in paragraph 391 of this judgment, then it shall be open to the state government to seek a writ of mandamus from this court. Para 368. We summarize our findings on the judicial review of the exercise of power by the President under Article 201 in withholding assent to a bill as follows. Section A, where the bill which is under consideration is pertaining to a provision of the Constitution where primacy has been given to the Union government in taking a decision, keeping in consideration the desirability of having certain uniform standards of national policy, then the limited grounds of judicial review would be based on arbitrariness, malefides, etc. Section B, where the bill which is under consideration pertains to a subject matter or domain within which state legislature has been accorded primacy, and the reservation of the bill is by the governor contrary to the aid and advice of the state council of ministers, then in exercise of judicial review the courts would be competent to look into the reasons for withholding of assent and whether they are legally tenable or not, besides the ground of malefice and arbitrariness, etc. Para 369. We clarify that the possible situations illustrated by above are not meant to be exhaustive, and in the specific facts of a given case, the courts may evolve new standards of judicial scrutiny to ensure that the constitutionally prescribed procedure is adhered to in letter and spirit. Section 6. What is the manner in which President under Article 201 of the Constitution is required to act once a bill has been reserved for his consideration by the Governor under Article 200 of the Constitution? Para 370. As we have discussed, Article 200 provides three courses of action to the Governor when a bill is presented to him: to assent, to withhold assent, or to reserve the bill for the consideration of the President. If he declares assent, then the bill becomes an act of the state legislature. If he withholds assent, then the procedure prescribed under the first proviso springs into motion. However, the procedure which is to be followed once a bill is reserved for the consideration of the President is provided in Article 201 of the Constitution. Article 201 was adopted without any debate in the Constituent Assembly on 1st August 1949. It reads as follows. Bills reserved for consideration. Quote, Article 201, bills reserved for consideration. When a bill is reserved by a governor for the consideration of the President shall declare either that he assents to the bill or that he withholds assent therefrom. Provided that where the bill is not a money bill, the President may direct the Governor to return the bill to the House, or as the case may be, the houses of the legislature of the state, together with such a message as is mentioned in the first proviso to Article 200. And when a bill is so returned, the House or Houses shall reconsider it accordingly within a period of 6 months from the date of receipt of such message, and if it is again passed by the House or Houses with or without amendment, it shall be presented again to the President for his consideration. End of quote. Para 371. A plain reading of Article 201 indicates that once a bill is reserved by the Governor for the consideration of the President has two options to choose from. He may either assent to the bill, which would bring the legislative process to a conclusion and the bill would become an act, or he may withhold his assent to the bill. Para 372. The proviso to Article 201 provides that in case of bills other than money bills, the President may direct the Governor to return the bill to the state legislature together with a message as is mentioned in the first proviso to Article 200. Once the bill is so returned, the state legislature is required to reconsider the bill in light of the suggestions of the President within a period of 6 months, and if the bill is passed again with or without amendments, it shall be presented again to the President for his consideration. Para 373. There are some features of Article 201 which are markedly different from Articles 111 and 200. The proviso to Article 111 as well as the first proviso to Article 200 mandate the President and the Governor respectively to assent to a bill which has been reconsidered by the Parliament and state legislature respectively and presented to them for the second time. However, the proviso to Article 201 does not place any such obligation on the President to mandatorily accord assent to a bill which is placed before him after reconsideration by the state legislature. This is evident from the absence of the expression "shall not withhold assent therefrom" in the proviso to Article 201. This is also brought out from the difference between the language employed in Articles 111 and 200 vis-a-vis that employed in Article 201. The first proviso to Article 111 uses the expression, and if the bill is passed again by the Houses with or without amendment and presented to the President for assent. Similarly, the first proviso to Article 200 also uses the expression, and if the bill is passed again by the House or Houses with or without amendment and presented to the Governor for assent. However, the proviso to Article 201 uses the expression, and if it is again passed by the House or Houses with or without amendment, it shall be presented again to the President for his consideration. Instead of the expression for assent, the proviso to Article 201 uses the expression for his consideration, thereby indicating that the President is not bound to accord assent to a bill even when it is presented to him for the second time. In other words, the object behind presentation of the bill for the second time after reconsideration under Articles 111 and 200 respectively is to obtain assent, whereas under Article 201, the object of the presentation is to yet again present the bill for the consideration of the President. Para 374. Further, the proviso to Article 201 places an obligation on the state legislature to reconsider the bill in accordance with the suggestions of the President within a period of 6 months from the date of receipt of the message containing the suggestions. There is no similar obligation on the Parliament or the state legislature to reconsider the bill within a stipulated time period under Articles 111 and 200 respectively. This absence of this 6 month period, this absence of this 6 month time period under Articles 111 and 200 respectively could also be seen as an indication of the primacy which is accorded to the Parliament and state legislature as regards the bill which is presented for assent under the said provisions. They may choose to repass the bill after taking into account the message which has been sent without being bound by the rigors of a time limit. This is because it is they who ultimately decide whether the bill would see the light of day or not, as far as Articles 111 or 200 are concerned. As discussed by us in the preceding paragraphs, under Articles 111 and 200 respectively, the bill would only fall through if the Parliament or the state legislature chooses or elects not to repass the concerned bill after it has been returned to them and the trust of expediency has been reposed on the constitutional head of the country and state, being the President and the Governor respectively. However, under Article 201, the prescription of the time limit of 6 months for the state legislature to reconsider the bill returned to them is indicative of the fact that the requirement to act expeditiously is also placed on the state legislature. Para 375. Any symptoms of lethargy exhibited by the state legislature, which is the recipient of a bill sent after the procedure under Article 201 is adopted, is viewed strictly by the Constitution. Here, inaction by the state legislature or delayed action by them in terms of repassing of the bill would cause the bill to fall through instead. The consequences of the failure to act promptly and in a punctual manner is more grave and severe for the state legislature under Article 201, since the premise is that the occasion for the reservation of a bill for the consideration of the President by the Governor may arise where a constitutional provision makes the assent of the President a condition precedent to a state legislation becoming enforceable or for the purpose of conferring some immunity upon the state legislation. Such a requirement can be found in Articles 31A, 31C, 254, Subclass 2, 288, Subclass 2, 360, Clause 4, Subclass A, Subclass 2, etc. 254, Clause 2, 288, Clause 2, 360, Clause 4, Subclass A, Subsection 2, etc. The second proviso to Article 200 also makes reservation for the consideration of the President mandatory. As we have also discussed, there may be certain other legitimate situations where the Governor may, in exercise of his discretion, reserve a bill for the consideration of the President. The matters attracting the aforesaid provisions require the procedure in Article 201 to be initiated since they pertain to areas wherein the centre could be said to have precedence or an edge over the state governments. This is because the considerations herein involve questions pertaining to the larger economic policy of the Union, safeguarding the fundamental rights of citizens and maintaining the integrity of the country as a whole. For example, the uniformity of policy across states for matters falling under the concurrent list would be a valid arena wherein the interest of the Union might need to be paid heed to in comparison with those of the states. Hence, a higher degree of the power of scrutiny of the President would be implicit in such matters, and he, having consulted the Union Council of Ministers, could be said to have the final say, which has the effect of overriding those wishes of the state legislature. Para 376. Para 376. The special object fulfilled by Article 201 and the important position it occupies in maintaining the quasi-federal structure of the country has been explained in detail by this court in Kaisari Hind, quoted supra as follows. Quote, para 76, ellipsis. The same could not be said with reference to the assent of the President envisaged under Articles 31A, 31C, 254, Clause 2 and 304, Subclause B of the Constitution. In my view, the assent envisaged in these articles by the very nature and character of the powers conferred constitute a distinct class and category of their own, different from the normal assent envisaged under Articles 111 of the President or Article 200 of the Governor. Article 201 also would indicate that even when for the second time the houses of the state legislature pass the bill and present for consideration, there is no compulsion for the President to accord assent. Therefore, the reservation of any bill act for the consideration of the President for according his assent, keeping in view also the above abject envisaged under Article 254, Clause 2, renders it qualitatively different from the ordinary assent to be given by the President to a bill passed by Parliament or that of the Governor to a bill passed by the legislatures of the state concerned. Para 77, ellipsis. The powers actually exercised by the President at any rate under Articles 31A, 31C, 254, Clause 2 and 304, Subclause B, are a special constituent power vested with the head of the Union as the protector and defender of the Constitution and safety valve to safeguard the fundamental rights of citizens and federal structure of the country's polity as adopted in the Constitution. A genuine, real, and effective consideration would depend upon specific and sufficient information being provided to him, inviting at any rate his attention to the central law with which the state law is considered or apprehended to be repugnant, and in the absence of any effort or exercise shown to have been undertaken when questioned before the courts, the state law cannot be permitted or allowed to have predominance or an overriding effect over that central enactment of Parliament to which no specific reference of the President at all has been invited to. This, in my view, is a must and an essential requirement to be satisfied, in the absence of which the consideration claimed would be one in a vacuum and really oblivious to the horde of legislations falling under the current list in force in the country and enacted by the Parliament. Ellipsis, end of quote. Emphasis supplied. Para 377. Dr. K.C. Markandan writes that Article 201 seeks to serve the same purpose in the legislative sphere as Article 365 seeks to do in the administrative sphere, namely make the Constitution unfederal in character, to establish the fact that the distribution of legislative power between the center and the states is not on an exclusive basis, but that the exercise of legislative power of the state is subject to the overall responsibility of the center and its legislative ambit. He states that no other explanation can justify the inclusion of this provision in the Constitution. Para 378. It is in such a background and context that the prescription of the 6-month time limit upon the state legislature for repassing the bill and presenting it before the President for his consideration assumes more significance. Non-adherence or any absence of deference to this time limit would prove to be detrimental to the cause of the state itself, since the balance of power is inherently skewed in favor of the Union on such matters. Having said so, and also conscientiously discussed by us in the preceding paragraphs. This is why the reference by the governor of bills for the consideration of the president must be strictly by and under the strength of clear provisions of the constitution. Para 379. The features of Article 201 which have been the cause of differences in center-state relations over the years are as follows. Section A. There is no time limit within which the President is required to declare the grant or withholding of assent under Article 201 once the bill is reserved for his consideration by the Governor. Unlike Articles 111 and 200 respectively, the expression as soon as possible is also not used. Owing to this, a number of bills enacted by the legislatures of various states remain pending with the President awaiting a decision. Section B. There being no obligation upon the President to mandatorily assent to a bill under Article 201, if a bill is reserved for the consideration of the President by the Governor acting in his discretion, then it has the effect of rendering the enactment of the bill by the state legislature nugatory if the President keeps the bill pending with him or declares the withholding of assent to such a bill. Para 380. As regards the issue of delay under Article 201, as we have discussed in the preceding paragraphs, the Sarkaria Commission observed that the delay in the expeditious disposal of bills reserved for the consideration of the President was one of the major causes of strain in center-state relations. It also recommended that definite timelines must be adopted for facilitating the efficient disposal of references under Article 201. The timelines suggested by the Commission are indicated in paragraph 120 of this judgment. Para 381. Besides prescribing timelines, the Commission also suggested that the reference being made by the Governor must be self-contained and contain all necessary information. We have discussed that the same was also observed by this court in Kesari Hind, quoted supra, in the context of references being made under Article 254, Clause 2. The reading of a timeline in Article 201 was also suggested by the Punchi Commission. Para 382. While the language of Article 201 does not provide for any timelines within which the President is required to act, the absence of a time limit cannot be construed as indicating that the discharge of functions by the President under the said article can be done without due deference to the important nature of the role they occupy as regards the legislative machinery of the state. Any bills reserved for the consideration of the President cannot become an act unless it receives the assent as is mentioned in Article 201, and thus long and undue delays in the disposal of references by the President would have the key effect of keeping the bills, which are an expression of the popular will embodied by the state legislature, in an indefinite and uncertain state of abeyance. Para 383. Although we are cognizant of the fact that in discharge of his powers under Article 201, the President is expected to consider the bill, and such consideration may be difficult to be bound by strict timelines, yet it cannot be a ground to justify inaction on part of the President. Para 384. We have discussed in detail in the preceding paragraphs that where no time for the exercise of power has been stipulated, such power must be exercised in a reasonable time so as to not render the subject matter nugatory or dilute the purpose sought to be achieved. The delay on part of the President in deciding a reference under Article 201 without any justification or necessity would fall foul of the basic constitutional principle that the exercise of a power must not be arbitrary and capricious. The implications of inaction being of a serious nature and detrimental to the federal fabric of the Constitution, there should be no scope for unnecessary delay on part of the President under Article 201 as well. Para 280, Para 385. At this juncture, we deem it apposite to refer to the office memorandum issued by the Ministry of Home Affairs, Government of India, dated 4th of February 2016 to all the ministries, departments of the Government of India regarding the expeditious disposal of state bills reserved for the assent of the President. The same is reproduced herein below. Urgent State Bill. File number 23 of 18 of 2015, Judicial and PP Part 3. Government of India upon Bharat Sarkar Ministry of Home Affairs or Grih Mantralaya, Judicial and PP section. NDCG 2 building, 4th floor, Jai Singh Road, New Delhi 110001. The February 4th of 2016. Office Memorandum. Subject: Guidelines on state legislations regarding. The undersigned is directed to invite to this ministry's DO letter number 23 of 33 of 1992, Judy, dated 22 of September 1992, duly conveying the guidelines formulated and approved by the Cabinet for disposal of state legislative proposals. Despite these clear guidelines, it is observed that undue delay is caused in taking a final decision on such bills. Number 2. The matter has been recently reviewed and a set of supplementary guidelines for expeditious examination and disposal of state legislative proposals by the central ministries, departments, state governments has been formulated. These are stated below for strict adherence. State bills, legislative proposals are to be examined in such a way that objections, views of the concerned central departments or ministries, if any, be meaningful, as addressing the unreasonable queries or observations delays the entire process. Item 2. A time limit of maximum 3 months be strictly adhered to for finalizing the bills after they are received from the state governments. Item 3. The ministry concerned should communicate their view on substantive issues within 15 days from the date of receipt of communication, and if they are not able to communicate, they should mention the reasons for the delay. In case departments or ministries are not able to communicate their comments or views in a period of 1 month, it will be construed that they have no comments to offer on the proposal. Number 4. The substantive issues involved in the bills should be dealt with by the ministries concerned, and issues relating to language, drafting, and bills' constitutional validity should be checked by the Ministry of Law. Number 5. As regards ordinances which are of urgent nature and are promulgated in view of the urgency, presently a time limit of 2 weeks has been permitted to the ministries or departments concerned for offering their views, but often the comments are not received within the prescribed time limit. Hence, as in the case of state bills, if the ministries or departments are not able to communicate their comments or views in the ordinances in a period of 2 weeks, it will be construed that they have no comments to offer on the proposal, and MHA or Ministry of Home Affairs will process in consultation with Department of Legal Affairs of the Memorandum of Law of the Ministry of Law and Justice so as to dispose the ordinances of within a period of 1 month from the date of their receipt in the Ministry of Home Affairs. Number 3. It is requested that all state bills, ordinances be processed in the light of aforesaid guidelines and within the time limit as specified. All the currently pending bills or ordinances may be reviewed urgently in terms of above guidelines in order to ensure their disposal within 3 weeks' time. Number 4. The receipt of this letter may kindly be acknowledged. Signed by Thankolun Hawokip, Under Secretary to the Government of India. Emphasis supplied. Para 386, the aforesaid memorandum indicates that the procedure involved after a reference is made to the President by the Governor is that the Union Ministry of Home Affairs, as the more nodal ministry, would refer the substantive issues involved in the bill to the appropriate ministry at the center which is concerned with the subject matter, and issues pertaining to the bill's language, drafting, or constitutional validity to the law ministry at the center. In this process, the office memorandum lays down strict guidelines directing the concerned central departments or ministries that the objections or views that they may have to the bill must be meaningful and precise. Such a stipulation has been laid down because the making of unreasonable queries or observations only serves to delay the entire process of consideration of a bill by the President under Article 201. The ministry concerned with the substantive issues as regards the bill is required to communicate their views to the Home Ministry within 15 days from the date of the receipt of the bill. If there is a deviation from the said time restriction, they must assign reasons for the delay that has ensued on their part. The failure to indicate so within a maximum period of 1 month is construed strictly and understood to mean that the concerned ministry may have no comments whatsoever to offer on the proposal. A perusal of the aforesaid also makes it clear that the timeline of 3 months has been prescribed for the decision on bills reserved for the President. A timeline of 3 weeks has been prescribed for the disposal of ordinances of an urgent nature. Para 387. Another office memorandum was issued by the Ministry of Home Affairs to all the states or union territories on the same date in this regard and is reproduced below. Urgent State Bill. File number 23 of 18 of 2015 Judicial and PP Part 3. Government of India, Bharat Sarkar, Ministry of Home Affairs, Grih Mantralaya, Judicial and PP Section. NDCG 2 Building, 4th floor, Jai Singh Road, New Delhi, 110001. The February 4th of 2016. Office Memorandum. Subject: Guidelines on state legislations regarding. The undersigned is directed to say that the Ministry of Home Affairs is the nodal ministry for processing and conveying a final decision with respect to state legislations under Article 201, read with Article 254, Clause 2 of the Constitution. State legislations requiring previous sanction of the President under Article 304, Subclause B of the Constitution, and ordinances for the instructions of the President under Article 213, Clause 1, etc. Number 2. On receipt of such a reference, this ministry examines and seeks the views of the concerned central departments or ministries. Once the views of the central departments or ministries concerned are obtained, these are again examined, and in any case of any objections, the same are shared with the state government concerned, seeking their views, clarifications, so that the central departments or ministries concerned can be apprised of the clarifications of the state government. This is an integral part of the present processing system. However, it has been observed that the state governments do not send requisite clarifications or views on the comments made by the central departments or ministries, and thus a decision in the matter gets unduly delayed. 3. Recently, the matter has been reviewed and a timeline of maximum 3 months has been fixed for disposing state bills or cases of previous instructions or ordinances from the date of their receipt from the state government. A maximum period of 1 month has been kept for interministerial consultation, and next 1 month has been kept for obtaining the comments, clarifications of the state government on the views as conveyed by the central departments or ministries. Since a time-bound disposal of state legislations, etc., is in the interest of the state governments, it is requested that appropriate instructions may be issued to all concerned to adhere to the timeline of 1 month for responding to the comments or views of the central departments or ministries as conveyed by the Ministry of Home Affairs. If the requisite clarifications or views are not received from the state government within the stipulated 1 month's time, it will be construed that the state government agrees with that observation and has no comments to offer. Para number 4. It has also been observed that many a time the bill etc. contains drafting errors, and state governments, despite repeated persuasion, do not withdraw such bills. Since a bill containing errors cannot be presented to the President, state governments are requested to kindly verify and check that a bill is free from any drafting or typological error. It is also observed that many a time the state governments agree to make amendments as per the suggestions of central ministries or departments, but still keeps on insisting for assent of the bill in its original form. It is therefore requested that once the state government tends to agree with the objections or views of the central departments or ministries, the state government may consider sending a consolidated proposal along with suggested amendments or modifications instead of insisting for assent of the bill in their original form. Para number 4. It is requested that all concerned may be instructed to follow the aforesaid guidelines scrupulously. All the existing cases pending with the state government may kindly be reviewed in the light of these guidelines in a time-bound manner. Para 5. The receipt of this letter may kindly be acknowledged. Signed by Thankolun Hawakip, Under Secretary to the Government of India. End of quote. Para 388. The aforesaid aforesaid memorandum then clarifies that when the appropriate ministry at the center, which is concerned with the substantive issues, makes any objections, the same is then shared with the concerned state government for further seeking their views or clarifications on the matter. This is done with the object of apprising the concerned central ministry of the clarifications of the state government on the matter. A time limit of 1 month has been prescribed for the same. As An aspect of concern highlighted therein, sorry, an aspect of concern highlighted herein was the inaction or delayed action on part of the state government to furnish these relevant clarifications, which further has the ripple effect of postponing the decision of the center on the matter. It was further prescribed that the state governments must rectify any drafting or typographical errors pointed out by the central government, and once the suggestions of the central government are accepted, the state governments should send a consolidated proposal containing the amendments rather than insisting on the assent to bill in the original form. Para 389. It becomes clear upon the perusal of the guidelines that in recognition of the urgent and important nature of Article 201, the central government has framed clear guidelines as regards the time limits and the manner in which references under Article 201 are expected to be disposed of. The guidelines also lay down that any delay caused in the seeking of clarifications and making of suggestions by any ministry would have to be explained by furnishing reasons, in the absence of which it would be assumed that they have no objections. It would be apposite for us to observe here that the idea of imposing timelines on the various stakeholders would not be antithetical or alien to the procedure that surrounds the discharge of constitutional functions under Article 201. The existence of the aforesaid two office memorandums further substantiates such an interpretation. After all, no memorandum which is contrary to the substance and spirit of Article 201 can be allowed to command any procedure between the Union and the states. The factum of its existence and acceptance reveals that the requirement of expeditious or even a strict time-bound action would be consistent with the aim and object of Article 201. Para 390. The recommendations made by the Sarkaria and Poonchi commissions, respectively, and the guidelines framed by the central government, taken collectively, indicate the expediency involved in the disposal of references under Article 201, along with the importance of the role of the President. In this backdrop, it must be made clear that the courts would not be powerless to intervene in cases where the exercise of function by a constitutional authority is not being done is not being done without a reasonable time or within a reasonable time. No idea. Para 391. We therefore deem it appropriate to adopt the timeline prescribed by the Ministry of Home Affairs in the aforesaid guidelines and prescribe that the President is required to take a decision on the bills reserved for his consideration by the Governor within a period of 3 months from the date on which such reference is received. In case of any delay beyond this period, appropriate reasons would have to be recorded and conveyed to the concerned state. The states are also required to be collaborative and extend cooperation by furnishing answers to the queries which may be raised and consider the suggestions made by the central government expeditiously. Para 392. We may now advert ourselves to the question on the nature of the proviso to Article 201 and whether it is intrinsically attached to the option of withholding of assent available to the President under Article 201, similar to how the first proviso is fastened to the option of withholding assent available to the Governor under Article 200. Furthermore, how and in what scenarios would the President resort to directing the Governor to return the house or houses together with a message? Para 393. This court in state of Punjab, quoted supra, had reached the conclusion that the option of withholding of assent under the substantive part of Article 200 would be tethered to the first proviso thereto, predominantly because of the clear use of the expression shall not withhold assent therefrom therein. It is limpid that an identical expression remains absent in the proviso to Article 201. Despite this, we must not lose sight of the fact that it was also authoritatively laid down in the same decision that a proviso may fulfill the purpose of being an exception or explanation or addition to the substantive provision of a statute. Therefore, despite the absence of a similar expression mandating the President to not withhold assent in the Proviso to Article 201, constitutional principles would require us to read the Proviso in conjunction with the option of withholding assent which the President is empowered to choose upon. Para 394. We say so because the scheme under which the constitutional heads of both the country and the state respectively are required to operate does not contemplate the idea of an absolute veto, thereby meaning that there can be no withholding of assent without furnishing of reasons. This is owing to the fact that the simpliciter withholding of assent both by the president and the governor would be impermissible within the fundamental principles of a constitutional democracy. Para 395. Since the notion of simpliciter withholding is an anathema to Article 200 of the Constitution, there cannot be any gainsaying that any withholding of assent in terms of Article 201 must also only take place on the strength of a specific provision of the Constitution that envisages the requirement of the assent of President in the first place, that is, those traceable to instances envisaged under Articles 31A, 31C, 254 clause 2, 288 clause 2, 360 clause 4, subclause 1, item A, etc., but also must be accompanied by sound and specific reasons that necessitate the withholding by clearly outlaying the policy considerations on which such an action is predicated. Para 396. While in the preceding paragraphs we have elaborated that the governor does not hold the power to exercise absolute veto on any bill, we see no reason why the same standard would also not apply to the president under Article 201 as well. The president is not an exception to this default rule which permeates throughout our constitution. Such unbridled powers cannot be said to remain in either of these constitutional posts. The only exception that has been carved out by the Constitution as regards the exercise of powers by the governor and that of the president under Articles 200 and 201 of the Constitution is that in the former, the governor, once having withheld assent from a bill, would then be bound to assent upon the reconsideration of such bill, whereas in the latter, no such compulsion is constitutionally imagined for the president, owing to the very fact that the grant or withholding of assent in terms of Article 201 is not the ordinary lawmaking procedure so far as the states are concerned. It is an extraordinary situation that only arises wherever policy considerations are involved in an otherwise state legislation, but nevertheless having the propensity of a pan-country effect that is necessitated by the very quasi-federal nature of our polity. Para 397. The natural corollary of the constitutional abhorrence to the notion of simpliciter withholding of assent within our constitution is that the requirement and responsibility of assigning reasons to the withholding of assent is cast upon the president. What follows from this is that the reasons assigned by the president for withholding of assent. Such an inference is legitimate since there remains no logic in assigning reasons if the same cannot be responded to and addressed by the state government. Putting the state government to proper notice of the reconsiderations or amendments to the bill which the Council of Ministers at the center may have is also an essential obligation inherent in such situations. In the absence of such communication, there exists a real and grave danger of denying the state government the knowledge of the reasons due to which the bill passed by the state legislature had not been assented to. Furthermore, there may exist situations where the state governments may be amenable to some remedial changes or amendments. However, in the absence of any communication, they may be robbed of any chance to undertake those changes and ensure that the bill becomes law in their state. The state governments must not be prevented from entertaining or possibly incorporating the changes or amendments to the bill which was originally referred to the President solely due to the absence of a transparent information sharing mechanism which the state government may be said to be entitled to in a federal polity. Entertaining such a dialogue assumes importance since the fulcrum of a healthy center-state relations in a constitutional democracy is the transparent collaboration and cooperation between the Union and the states. Para 398. The mandate for an effective and purposeful dialogue has been constitutionally recognized and approved through the proviso to Article 201. Making the exercise of this proviso optional or subjecting it to the discretion of the President to use wherever and whenever he deems fit would deprive the states of an important safeguard which has been clearly laid down in the Constitution. Although we are not oblivious to the fact that the office memorandums referred by us above provide an opportunity for the state government to respond to the objections that the concerned ministry at the center may have, we must remember that such an office memorandum cannot be used to bypass a procedure already laid down in the text of the Constitution. Furthermore, the sending of objections and receipt of clarifications to and from the state government while the proposed bill is under consideration of the President through the concerned ministry at the center is to enable and infuse an informed decision making in the entire process to avoid any haste or non application of mind before taking any decision of either grant of assent or withholding thereof in the first place. Para 399. However, at this stage, we may clarify that although the memorandum mandates that there must be a channel of transparent and purposeful communication between the state government and the central government, yet this does not mean that the requirement of sending a message in terms of the proviso to Article 201 is eliminated. Mere existence of any communication that may take place prior to any decision being taken under Article 201 is no reason to shirk the constitutional responsibility of officially communicating the message to the concerned state legislature. There lies a very fundamental difference between the communication envisaged under the memorandum and that under the proviso to Article 201. The former is only to address any primary objections or doubts as regards the proposed bill and which prevent a meaningful decision from being taken by the President under Article 201, whereas under the latter, the idea is to communicate the reasons as to how the President arrived at his decision to withhold assent, along with specifying the provisions of the proposed bill that should be reconsidered by the state legislature. Para 400. In other words, the sending of parliamentary objections under the memorandum cannot be equated to the message. Para 400. In other words, the sending of preliminary objections under the memorandum cannot be equated to the message under the proviso to Article 201, which is used to communicate the aspects of the proposed bill to be reconsidered and how they may be reconsidered by the state legislature. Unlike the memorandum, the message under Article 201 of the Constitution is of seminal significance inasmuch as it facilitates the repassing of the bill by the state legislature. What emerges from the aforesaid is that when the President declares the withholding of assent of the state legislature's proposed bill, it would be his constitutionally bounden duty to also set into motion the proviso to Article 201. Para 401. In short, after due consultation with the state government, the President may either declare assent to the bill or he may declare that he withholds assent thereto. It would not be appropriate for the President to declare withholding of assent without first seeking clarifications from the state government, as is mentioned in the guidelines featuring in the office memorandums. If, in the course of discussions, the state government expresses willingness to make such changes to the bill as may be suggested by the central government, then it would be open to the President to seek reconsideration of the bill by invoking the proviso, and upon the bill being reconsidered and passed with such changes, the President may grant assent thereto. Para 402. At this stage, it would be prudent for the President, while choosing to withhold assent to the bill and setting the proviso into motion, to address the issues, views, changes, amendments, or recommendations that he may have comprehensively and in one go. Piecemeal exercise of the proviso to Article 201 must be dissuaded. This is to prevent the endless loop of sending and resending of the bill that may ensue between the President acting under the proviso to Article 201 and the House or Houses of the state legislature. A purposive interpretation of Article 201 does not in any manner envisage a never-ending cycle of communications between the President and the state government. Such conduct would tantamount to abusing the essence of the proviso, which embodies fostering a collaborative spirit between the Union and the states. Therefore, the exercise of the power under the proviso must also be done in good faith and in a bona fide manner. Para 403. The object underlying Article 201 and the significance it holds for the enforceability of state legislation would be frustrated if the procedure therein is reduced to an endless cycle of back and forth without any chance for fruition of the aspirations of the people of the state on mere technicalities. Therefore, the President is expected to follow the procedure envisaged under the proviso with a sense of responsibility whenever necessary. In the ordinary course of action, a bill must be sent back for the reconsideration of the state legislature under the proviso to Article 201 only once. After the bill is sent to para 404, after the bill is sent with a message to state legislature by the president and they repass it with or without amendments, the president would be empowered to take a final call on the giving or withholding of assent on the bill concerned. If he chooses to assent to the bill, it would become law. There is no gainsaying to the fact that the President under Article 201 is conferred with the power to withhold a bill during the second round without activating any other procedure, effectively bringing the legislative process vis-a-vis that same bill to an end. In contrast to this scheme of Article 200, wherein the governor must mandatorily accord his assent to a bill which is presented to him for the second time. Para 405. However, if he chooses to withhold his assent, the bill will not take birth as law. It must, however, be noted that even during the withholding of assent of a bill received on the second round, the President would be required to assign clear and sufficiently detailed reasons for arriving at such a decision. Even in the second round, he whatsoever to exercise absolute veto, as the constitution does not provide anywhere that withholding of assent can be done simpliciter. Hence the decision option of withholding assent after having set into motion the proviso to article 201 must not be misconstrued to mean that he is exercising an absolute veto or a power of a similar nature. We say so first we say so because first the decision has not been arrived at in the single sorry the decision has not been arrived at in this first instance without communicating reasons to the state legislature and providing them with an opportunity to reconsider the bill. And secondly, the president is mandated to declare the withholding of assent to the repassed bill with cogent and sufficient reasons at this stage as well. Para 406. Where the reservation is on the ground of repugnancy of the state legislation with the legislation or under one of the provisions where the assent of president has been envisaged for the purpose of enforceability or imparting immunity to the legislation, it would be a matter where the president would decide the question of grant of assent, keeping in mind the desire of having a uniformity in the policy across the country on the subject matter involved. This, as was held in Kesari Hind quoted Supra, is a fact that the assent under Article 201 is not the same as the assent granted under Articles 111 and 201, and the President has been given supremacy under the Constitution as regards the bills covered under Article 201 by virtue of his constituent powers. In this regard, the observations of the Sarkaria Commission may be referred to as guiding principles by the President, wherein it was observed thus, quote, para 5.10.2. While we agree that the scrutiny by the Union government need not be to the general constitutionality of the bill or conformity with the constitutional provisions under which the bill has been reserved, we would send a note of caution that non-conformity of a state bill to the policy of the Union government is not always a safe ground for withholding presidential assent from it. In this connection, it is necessary to keep in mind the general principles that the division of legislative powers between the Union and the states with reference to 1, 2, and 3 of the 7th schedule. All matters in the Constitution are manifestly of common interest to the Union and the states. The supervisory powers conferred on the Union under Articles 201 and 254 Clause 2 enable it to secure a broad uniformity in the main principles of the laws on concurrent list subjects throughout the country. 5.10.3. From a functional angle, all matters in List 2 cannot be said to be exclusively of state or local concern. Several entries in List 2 are either expressly subject to certain entries in List 1 or overlap to some extent matters in List 1 or List 3. Securing uniformity and coordinating policy on the basic aspects of such matters in List 2, having an interface with those in List 1, cannot be extraneous to the functions exercised by the President in considering state bills under Article 201. Para 5.10.4. Articles 31A, Clause 1, 31C, 288 clause 2 and article 304 subclause b provide for reservation of certain types of state bills for the consideration and assent of the president. These provisions, read with article 201, enable the union executive to ensure on the basic aspects of these special matters a certain degree of uniformity in the interests of the social and economic unity of the country. Examination of the state bills of this special category from the point of their contempt sorry from the point of their compatibility with the settled policy of the union therefore does not involve any impropriety. President should not withhold assent merely on consideration of policy differences with respect to matters in list 2. Para 5.10.5. Apart from all such matters on which a measure of uniform coordinated policy is desirable, there remains in list 2 an area which is purely of local or domestic concern to the states. It is with respect to bills falling within this area of exclusive state concern that utmost caution, circumspection, and restraint on the part of the Union Executive is required in the exercise of its supervisory powers under Article 201. This is all the more necessary if the bill has been reserved by the governor in the exercise of his discretion, contrary to the advice of his ministers. It may not be prudent to veto such a bill merely on the ground that the legislative policy of the bill, though otherwise constitutional, does not conform with what the union government thinks should be its policy with respect to the subject matter of the bill. Para 5.10.6. We recommend that as a matter of convention, the President should not withhold assent only on the consideration of policy differences on matters relating in pith and substance to the state list, except on the grounds of patent unconstitutionality, such as those indicated in para 5.6.13 above. End of quote. Para 407. Where the ground of reservation of a bill is patent unconstitutionality of a nature described in the exceptional situations in MP Special Police quoted supra, that is where the bill upon becoming law would be a peril to democracy, the decision of the President must be guided by the fact that it is the constitutional courts that have been conferred with the ultimate authority of interpretation of the Constitution and the laws. Para 408. When a legislation is apprehended to be patently unconstitutional of the nature described in the above paragraph, the courts, as the sentinel on qui vive, have been empowered by the Constitution to test the virus of such legislation, and there is no bar or limitation to the power of judicial review of the courts in this regard. This is in consonance with the constitutional scheme of checks and balances between the three wings of the government so as to ensure that absolute power does not vest in one authority. Therefore, the power of judicial review by design acts as more than a sufficient safeguard against the enactment of an unconstitutional legislation by the legislature. Para 409. However, in cases of challenge to legislations duly passed by the legislature and assented to by the executive, the constitutional courts temper their judicial review with the presumption that such legislation is constitutional. This is because the courts deem it appropriate to not interfere with an enactment that has been passed in the wisdom of the legislature people. It is in this context that we to note the remarks of the eminent constitutional jurist Nani Palki on the object of assent by the executive to a bill. Quote, the object of enacting these provisions, that is Articles 200 and 201, was perhaps that while the constitutionality of a law can be challenged in a court, its wisdom it would be better to prevent a clearly unconstitutional legislation becoming a law than to have it invalidated by a court later. End of quote. However, the aforesaid statement should not be construed devoid of its context, more particularly in ignorance of Article 143 of the Constitution, which we shall now discuss. Para 410. We are in agreement that one of the objects of Article 201 is also to prevent a bill that is perilous to democratic principles. However, we are also of the view that a bill appearing to be unconstitutional must be assessed by a judicial mind. It is for this reason that both the Sarkaria Commission and the Punchi Commission categorically recommend the President to seek the opinion of this court under Article 143 in respect of bills that may be apprehended to be patently unconstitutional. Para 411. Article 143 confers on the President the power to consult this court any time when it appears to the President that a question of law or fact has arisen or is likely to arise, which is of such a nature and of such public importance that it is expedient to obtain the opinion of this court upon it. Therefore, the President is Para 420. Since the constitutionality of a bill is a matter which falls within the exclusive domain of the courts, the opinion rendered by the Supreme Court under Article 143 holds high persuasive value and should ordinarily be accepted by the legislature and the executive. We are no strangers to the arguments as regards the non binding nature of the advisory jurisdiction of this court, and that even though a bill may be referred to this court by the President under Article 143, yet the opinion delivered thereunder may not be heeded. However, merely because the jurisdiction under Article 143 is not binding does not undermine the principles used by this court to determine the constitutionality of the bill. This court, in re special courts quoted supra, has held thus. Quote, Para 34. Learned counsel for the interveners who oppose the reference urged as one of the planks of attack on the reference that it is futile for us to consider the constitutional validity of the bill because whatever view we may take, it will still be open to the Parliament to discuss the bill and to pass or not to pass it as it pleases. This argument proceeds upon an unrealistic basis, its assumption being that the Parliament will not act in a fair and proper manner. True that nothing that we say in this opinion can defer the Parliament from proceeding with the bill or dropping it. That is because no court will issue a writ or order restraining the Parliament from proceeding with the consideration of a bill pending before it. But we cannot assume what seems to us to be unfair to that august body, that even if we hold that the bill is unconstitutional, the Parliament will proceed to pass it without removing the defects from which it is shown to suffer. Since the constitutionality of the bill is a matter which falls within the exclusive domain of the courts, we trust that the Parliament will not fail to take notice of the court's decision. End of quote. End of emphasis. Emphasis was supplied. Para 421. In our considered view, the only reason for which the legislative or the executive wing may not take note of the opinion delivered by the Supreme Court under Article 143 is when the grounds on which a state bill was reserved for the consideration of the President are not purely legal but also involve certain policy considerations which may outweigh the issue of constitutionality. In such cases, if the President acts contrary to the advice of this court and withholds assent to a bill, he must record cogent reasons and materials that justify not granting assent. Para 430. Coming to the facts of the present case, the Governor first withheld the 10 bills under question and later, despite the said bills being repassed by the state legislature and presented for him again under the first proviso to Article 200, still reserved them for the consideration of the President. We have elaborated in detail that owing to the clear language in which the first proviso is couched, there would never arise, except in extraordinary situations, any occasion for the Governor to reserve a reconsidered bill for the consideration of the President. The said bills, in the absence of any message given by the Governor under the first proviso, were taken up for reconsideration by the State Assembly and passed in their original form and presented to the Governor for his assent. Thus, undoubtedly, it was not open to the Governor to reserve the bills for the consideration of the President, and he ought to have granted assent. Para 431. Considerable time has elapsed since these 10 bills were originally passed and presented to the Governor for assent. 2 out of the 10 bills even date back to 2020. It is important to keep in mind that the tenure of the state legislature is of 5 years and the representatives are accountable to their electorate as regards the enactment of legislations addressing the issues faced by the electorate. At the end of every 5 years, the elected representatives have to go back to their electorate and provide a report card based upon which the people in whom the ultimate sovereignty rests cast their votes. Bills, if kept pending for long despite their passage by the state legislature, militate against this very fundamental essential to the sustenance of a